78.
78.
Part 3 is very good, sir. So 78 is application, that this part shall apply to matters relating. You know when this was when this came into force? This came into force exactly 3 years after the IBC code came into force for CIRP. That is 1st of December 2019. But from 2019, not many cases were admitted. Now, for last 6 months, we are seeing ample number of cases being admitted in this because both the hurdles have been cleared by Supreme Court. So, application is interesting. Here you need to have only a default of 1,000 rupees. Unlike CIRP had 1 lakh, which was now changed to 1 crore. Here it is still 1,000 rupees. Now it's a different matter that, the application fees itself is 2,000 rupees to file a CP in under this chapter. But default can only be 1,000 and you can come here. If some of you are not aware, those two provincial acts of 1999, if anyone remembers in Madras, there the default is 500 rupees. So in that era, it was 500 and we still have 1,000 rupees right now. So 1,000 rupees default, you can come here. So this is another venue for bankers. If somebody is here or somebody has taken guarantees, if let's say the threshold of 1 crore is not getting satisfied for CIRP, we can come to this section, and here we don't need 1 crore default. It can be less than that and we can start the proceedings. So 1,000 is the default. Then it talks about definitions. Who will be?
Interrupt you, but you are not audible.
Not audible. Okay. Can you hear me now? Is it better?
No, it is fine. Absolutely fine.
Okay. Okay. Thank you. Ma'am, please check maybe something on your side also. Okay. Definitions talks about the adjudicating authority. See, this definition of adjudicating authority talks about the entire spectrum in the sense partnership firms, etc., etc. Right now, whenever we are dealing with personal guarantors to corporate debtor, and all the decisions which have come till now, the adjudicating authority for our matter, for what is going on today, is NCLT and not DRT. Associates of debtor, associates, we all know, immediate family member, debtor, relative, spouse, your employee, any person you are in partnership with, spouse, or grandfather, nana ji, all that will come into this. Employer, your ex-employee, all those also comes into this. So here we talk about the definitions. I don't know whether definitions are really that important. Whenever you get a case in this section, just refer once more. It'll be pretty clear. So associate of a debtor means anybody related to him directly, not at an arm's length, maybe a closer person. It also talks about so what a bankrupt means. Okay, bankrupt means a person who has been adjudged as a bankrupt. So there's a difference between bankrupt and insolvent. Insolvent is somebody who has not been able to do anything right now. Bankrupt is who really doesn't have anything. Court has ordered him as such. Whatever is left with him, you take it, divide it, proceed. Give him discharge. From personal insolvency, there is a comeback. From bankruptcy, there is no comeback. You are adjudged bankrupt and then you can only be discharged. Here, if your repayment plan is passed, you can bounce back. You can also come back as like how we do 12A, right? It can still be there. Bankruptcy means state of being bankrupt, bankruptcy debt. So see, as I said, this section 79 is on the entire chapter. Today we are only doing chapter 1 and 3. We are not doing chapter 2. And we are not also doing chapter 4 and 5 later on. We are only doing chapter 1, which is definitions, application and definitions, and then we'll straight away go to the 94, 95 onwards till 120. So bankruptcy, let me keep it for some other day because bankruptcy we are not touching today. Committee of creditors, similar meaning what we have learned in CIRP. If anybody does not know any of these meaning, please stop me because I'm thinking that many of us are uh, have already been through. We all know what is committee of creditors, so I'm not spending time here. Uh, Debtor is obviously the judgment debtor. Discharge order will again come later. Excluded assets will also come in the bankruptcy part. It is not in the insolvency. Personal insolvency has no meaning. Excluded debt also, there are some debts which a person cannot waive off, cannot let go. They will always remain with the person. That is excluded debt. Again, it's a part in the what you call bankruptcy. Right now, it's not important for us. Immediate family, we have learned, we know what is immediate family. Partnership, that is, if it is a partnership, that is also not notified yet, not required. Doesn't mean a repayment plan. Okay. A repayment plan means a plan prepared by the debtor in consultation with the RP, okay, under 105, containing a proposal to the COC for restructuring of his debts or affairs. So this is kind of OTS or restructuring. Why we don't call it OTS? Because OTS normally talks about one-time payment, right? One-time settlement. Here, this debt can be restructured over years also, over months also, or in one go also. So again, repayment plan is in consultation with the RP, with the IP. So I'm assuming most of us are here as IP. It has to be a consultative process. It is not a coercive process. Please remember this word. It is not a coercive process like in CIRP. CIRP, we take over the assets from the CD as 12 management. We file 19.2, etc., etc., right? Here we don't need all that. No need to file any 19.2. No need to file any non-cooperation. Nothing. It is the last chance given to the personal guarantor to come out of this situation. And that is why at times it's surprising why they fight against, these applications, because it's a golden chance for them to come out of it. Say that this is what is available with me. Want to take it? Please take it. Let me go. An amazing chance. But still, you might have realized in the courts, uh, they vehemently oppose even this application on one ground or the other. But as RP, let us focus on our energy on consulting, giving the person a fair advice how the resolution plan should be made, what all it should contain, all it should leave out, should not leave out, uh, to the best of the capability of the person as on date. Fine. Undischarged bankrupt, again, will not touch it. Uh, Chapter 4 is the fresh start process. So fresh start is normally when there is nothing left. There is no money left. It's like early dissolution, right? So this person literally has nothing. You feel that, is down the drains almost. So there is no meaning of, running the entire process. Allow that fresh start and then, so this is a very condensed part of it. So, but it is not yet notified, so will not go into this. So 80 to 92, we will skip it. Effect of application, objection, application, general duties. Here also they want replacement of resolution process. Okay. After 92 discharge, so that part is over. We come to chapter number 3, which is our insolvency resolution process. Fine. What does it say? It starts page 95. Let me just make it a little bigger for you. So, okay. So chapter 94. You know, we have section 7, 9, 10, right? 94 is section 10. Section 10 means the CD can go himself, correct? Corporate debtor can go himself. 94 also, the person can go himself, saying, I'm currently insolvent. I am not able to pay my dues. This is my application. Kindly allow me to restructure. He can propose his repayment plan. So 94 is akin to section 10. So if you know CIRP, you know 94. A debtor who commits a default may apply either personally or through a RP to the AA for initiating the resolution. Again, when it's a firm, it will be applied on all. We haven't seen, I personally have not seen many firms going. Right now, only individuals are going into this process. This shall be submitted only in respect of debts which are not excluded debts. Excluded debts are debts which cannot be waived off through this process, right? Like if, let's say you have a matrimonial, dispute, family dispute of, let's say, divorce or something going on, that cannot be excluded. If you have a student loan you have recently taken, you come here, you ask that, I'm not able to pay off my loan, give me a fresh start. It's not possible. Student loan cannot be done away with. So those are excluded debts. Other than that, most of the debts can be covered under. Debtor shall not be entitled to make an application if he is an undischarged bankrupt, undergoing CIRP. These are when somebody has recently done it, or if one has started, second cannot start simultaneously like that. Like if one CIRP application has been admitted, another cannot be admitted because the same person can go to RP and file its claim. It's the same process, right? So if it has recently started, is still an undischarged, it cannot be started. Other than that, there is no embargo on start. A debtor shall not be eligible to apply under this section if he has been admitted in respect, if and 12 months prior also, right? So you cannot do that. You continue under moratorium for 5 years. Like you do it, finish it, it's not getting finished, you restart it. Nothing like that. So if it was done prior 12 months in priority, then also it cannot be it. See, whenever they start 94, like in section 10, section 10 applications are very hard to get admitted because mostly there is a element of fraud, defrauding the creditors. Here also courts are pretty, vigilant on this part that this application has not been filed just to get away from the rigors of law. And that is why even admitting a section 94 application is a very uphill task where there's supposed to be no objection because the person himself is saying I'm insolvent. What else you need to prove? The person is saying I have committed default. You only need to commit a default of 1,000 rupees. You are not doing it. It should be started, right? But and even if one of my case, it is going on for last 3.5 years. It has not been admitted yet. So it goes on. The courts are pretty skeptical, when they think the applications are, for defrauding.
Devrat ji,
Hence, Anil sir.
huh, when the law itself is allowing individual
Yes,
to take the court help of court to get discharged, then how why NCLTs are coming into interpretation and coming in the way in the process?
exactly. Exactly, sir. So, as I said, they are skeptical only for one reason, saying that these applications are not filed for defrauding the
So
creditors,
how
just to
can you
avoid
start?
that.
How can you start the with this premise only? The court can start with this premise.
Uh,
I,
Sir,
I am not I am not
I
able
have
to.
given you, I just given you an example.
Uh,
Three and a
so
half years, one matter has not been admitted.
this is mockery of the law. I have a right. I am not able to deal with my debts, so I have to go to the court. Law is to my help to get discharged.
Somehow I
want-
agree with you, sir. I tend to agree with you.
Uh,
But I'm telling you what is the factual
I
situation
know,
right
I
now.
know.
So,
Many, but my disappointment is that when this is happening, the regulatory bodies are silent on these very, very important issues.
because who knows better than the person himself that I am insolvent? And if the
Yes,
person himself is saying, what else you need to prove?
if
Hardly anything.
the person has done something wrong, so there are enough provisions in the law to prove that he has taken away the money. Have you
Correct,
proved
sir.
in the case of in the CRP also, the corporate debtor has defrauded, diversion of funds has taken place, but
Sir,
that is
unluckily, there is a small difference. In CIRP, you have PUFE applications, etc., etc. Whereas in personal insolvency, there is no such thing,
so let them start
right?
bankruptcy trustee process.
Yeah, that
If
is after, that is
so
post this, right?
if the
Exactly.
creditors are doubtful of the character of the person, they can
It
start.
will fail. Yes, this will fail and it will go to bankruptcy. So,
They have a right
I,
to start bankruptcy trustee, but let the process run smoothly and fastly.
I tend to agree with you, sir, somewhere, but factual situations we are discussing right now.
I know, I know,
This let's
I
keep
know.
it in the end.
Yes,
We'll
yes.
discuss.
But these are practical challenges which is failing our a very good IBC law. You know, the noble
Yes,
intent of the IBC law to get the debt resolved is getting
correct,
defeated in the process,
correct,
and people take misuse of that. You know.
correct. Okay, so we'll go through. We'll go to the next step. 94 is when you are
Sir, good
doing
morning.
yourself.
Sorry to interrupt, sir. Rana, sir. That
Yes, Mr. Rao.
two items are excluded debts. So one is education loan, another one, sir.
Oh no, sir. There are other debts like which are court has imposed. Say they have imposed a penalty on you.
Okay.
Suppose you have run away from the court. They had put 25 lakhs on you. Right? There was some murder case going on, something. So those kind of debts which the court has imposed on you, or education loan, or you have to pay maintenance to your wife, that kind of debt which was given by the court, those cannot be excluded. Rest everything can be
Okay,
done
thank
away
you.
with this. Yeah. So like 95, 94, we will go to 95. 95 is when so 95 is section 7 or 9, right? So here there is no individual doesn't give personal guarantee to an operational creditor normally,
Yes,
right?
normally.
We haven't seen that. So that is why mostly the banks or NBFCs or ARCs comes into picture here. They apply under 95. Similar proceedings, you give notice, you give a 14-day notice. If you want, I can read it little slowly, so people who are not even very conversant, they can understand. A creditor may apply either by himself or with other creditors or through a resolution professional and submit this. Pay 2,000 rupees CP fees. Say in section 7, the fees is 25,000. Here it is only 2,000 in both the cases, 94, 95. A
Uh,
creditor may apply.
Ranaji, one question, can I disturb? In the
Yes.
excluded debt, uh, that section 138, that check bouncing cases, criminal offense, that can be excluded.
So
I think
depends.
you are
See,
covered.
criminal
Creditor, you're going to
liabilities are
discuss.
excluded, but the debt, if it was arise out of something, can be, yes, why not?
You have discussed excluded debt, or you're going to discuss?
I will discuss. I will.
I said you.
If we
Okay,
want, we will discuss it, sir.
at that time I
Yes,
will
yes,
read the
yes,
word.
we will discuss
Okay.
that.
I thought
Where an
you.
applic No, sir, we will discuss that. So I
Mhm.
kept it for bankruptcy part, but we will discuss that.
No, that is
Where an
important, sir.
application,
I'm facing few challenges in the PIB process, so I
we
need
will do.
clarity from you.
We will do that, sir. Where an application has been made against one partner, obviously it will be for every other partner, and it will be. This has again not been enforced right now. An application under Section 1 shall be accompanied with all the details, the debt owned by the creditor, the failure of the debtor to pay the debt within a 14 days service of notice, relevant evidence of such default can be given, maybe NESL. See, personal insolvency doesn't come on NESL right now. We haven't seen. I have personally not seen. So CIRP, it was easier. Here it's little tough. But now banks are putting on NESL also. Whenever they are giving any loan, they are asking the person to accept it on IU, which is NESL currently. Creditor shall also provide a copy of the application made under Section 1 to the debtor and to the board as prescribed. Board means IBPR. Now, there is a pretty different approach which has been taken here vis-a-vis CIRP is concerned. CIRP on application, there is no moratorium. Moratorium is only on initiation of CIRP, whether it's after 1 year, 2 year, 3 year, whenever. Law says it should be within 14 days, but let's say if it takes 2 years, then after 2 years only the moratorium starts. In personal insolvency, moratorium kicks in on day 1. On day 1 means not on the filing, but on clearing of scrutiny. So it's not like you file, absurd application, it doesn't get clear, it kicks on. No, it starts on the clearing of the scrutiny whenever the IA is allotted. So the moment IAs are allotted, the interim moratorium kicks in. And why we call it interim? Because it's only for the time being till the actual insolvency process starts. That is why we call it interim moratorium. But it has similar effect. Moratorium is moratorium, whether you call it interim or final or whatever. Interim moratorium starts either on 94 and 95. So many of these 94 applications are filed just to enjoy 96. Because the moment 96 starts, there is no interest, nothing, which gets on. So that is why, as Mr. Anilji was asking earlier, why 94? Many 94 were filed only for this reason. An interim moratorium.
That is the privilege the debtor has.
Law has provided. Correct.
So
Correct.
I want to save myself from the atrocities of sale of my home where I am residing.
I agree. So an interim moratorium shall commence on the date of application. During the moratorium period, any legal action or proceeding pending in respect of any debt shall be deemed to have been stayed. There is no notice required, separate notice. Creditors of the debtor shall not initiate any legal action or proceedings in respect. And if it was starting, it will be deemed stayed, like surface will stop, everything will stop. Where the application has been made in relation to a firm, it will be on everybody in the firm. Now, this is a stage where appointment of RP is done. So Section 97 talks about appointment of RP. Whereas many says that appointment of RP is only an order in Section 100, which is admission. So 97 talks about appointment of RP. If the application is filed through RP, the AA shall direct the board or check the panel. Now NCLTs also have staff which checks on the eligibility of IP, any proceedings going on by IBPI on him or not, whether he's eligible, and then only they allow it. So if it is through an RP, you have filed it, that same RP will be allowed. If it is not filed, now luckily here both of them have an option. See, in Section 7, there is no option of not suggesting an RP. Whereas in 94 and 95, both have an option of not suggesting. The person can be appointed from the panel. Even the bankers have an option of not suggesting. So they can also do that. And in that case, NCLT appoints from the panel. But if it is filed through, if it is proposed, then they will appoint the same person. It says within 7 days, all this is not important. Rejection can only be on the ground of incapability, right? If the person, there is some disciplinary action taken or is no more there, in that case it can be. Otherwise, same person will be reappointed. 7 days, 10 days really doesn't matter for our life. Replacement. 98 is replacement of RP. As I said in the beginning, it's a consultative process. So whenever the PG or let's say the FC also, when they think that RP who is appointed under this is required to be replaced, they can apply and it should be done. No questions asked. And
This is-
RP should also not take it on heart that, why they are changing me, because end of the day, it's their right. We are always a neutral party. If somebody wants our job, fine. If they don't want us on the job, they feel somebody else can do a better job, let them do it. We should allow it. There's a
Oh,
recent case in this matter. We'll discuss if the time permits. India Bulls case, which has happened recently. I think it was discussed a lot in the last 1 month. We
yes.
will also
But
try
this,
and touch it. Yeah.
Devraji, this provision is derogatory. This is not a fair provision that any time any person creditor or the debtor they want to change replace the IP or they can replace the IP without assigning any reason. So where is the indispensability or dignity maintained of the insolvency professional?
Sir, as you said, the law allows them. So this is
So
the
this
law
provision,
allowing
as
them.
a recent judgment where the Mr. Goenka has said that he doesn't have faith in the IP. IP is a member of Insolvency Bankruptcy Board of India. He is a qualified person. Somebody is making a statement, he doesn't have a faith. So how he develops faith in some other IP?
Uh, Sir, I want to keep that for towards the end of the session because
This is
then it's a touchy issue. So
uh,
let's not go
uh,
there. All the IPs will jump in. So I will keep it for in the end. If you can see, I have kept this here. This is the Mr. Subhash Chandra case. Will touch that, but let's keep it in the end. That's why I've kept it in the last tab of my presentation.
yeah.
But replacement is allowed, and whenever they feel they can ask to change it. No, should not. No reason has to be assigned.
So
Uh,
meaning thereby the RP should work at the mercy of all these people. That's all. He should keep them in
current
good
cu-
humor.
currently it looks
Uh,
like that.
he
So
should keep
yes,
them in good humor. If they are not happy with him for any reason, then they can file an application for replacement. That's all.
unluckily yes. Okay, let's say nobody replaces us. 98 is not there. So 96 moratorium started. 97 the person was appointed. Now what the person has to do is in under section 99 you submit a report. A report has to be done within 10 days. So timelines are always stringent on RP. So obviously within 10 days we have to take all the so what it says 95 99 it says we shall examine 94 95 submit a report recommending approval or rejection. Where
Okay.
application by 95, RP may require the debtor to prove if the payment has been done. Let's say if the payment has been done, then there is no issue, then obviously it cannot be admitted. You take evidence of electronic transfer, evidence of encashment, and story is over. If it is not done, then you examine whether deed of guarantee was correct, whether limitation is there or not. So what a judge is going to do, what the Honorable AA will be doing, you do a preliminary scrutiny of that. Your job is only that. Checking limitation, checking whether deed of guarantee is there, whether right parties are there, fair enough. Whether the person is alive, whether they are communicating also with you or not. Many a times they don't even try to respond. They say we are
Yes.
only filing an appeal. So in some cases they give you. In one of my case, they gave me 1,000-page document. They said do it in 10 days. How will a person do it in 10 days? We go through everything and check that mountain of documents. So they try every thing in the book. But our job is to identify if the application is correct and whether it should be admitted. You have a right to reject it also. But again, if you reject it, then there is no appointment of RP, and maybe one reason where RP tends to recommend for admission more so that they can be appointed, right? So, I mean, that is also a part of it because the same person has to be appointed. Why will somebody say don't start it? Because if we don't start it, then he will not be appointed.
But if there is a case, he has already paid or there is a case not to be accepted, not to come and initiate the process. He
Other
must,
than that, sir,
uh,
other than that,
he
other
must,
than he
he
must,
must be
I
fair.
agree with you. I'm only saying, sir, it's little unfair because see, when you accept that the admission is done at section at the stage of 100, then it will be unfair. But if you accept that it is the person is appointed, the RP is appointed at 97, then it looks pretty fair because then he's giving a fair advice.
Yeah.
If you say his fees will only come after 100, obviously there are incentives for the person to get this admitted. Okay. So let's learn the law, then we will learn the problems. Okay. First, we will learn the law. Where the debt for which an application has been filed by a creditor is registered with IU, the debtor shall not be entitled to dispute. Here, there is hardly any dispute actually, if you know. Whether you have made the payment or not, that is the actual thing we need to check. Rest all is not that important. Person from whom information or explanation is sought under subsection 4 shall furnish such information within 7 days. So they take 7 days to inform you, and then you have only 3 days to do it. And when will you file the application? So literally the time is pretty squeezed. Huh? You need to act very, very fast the day you get the order. Fine. RP shall examine the application, check whether 94, 95, all the as per the rules it is correct. They will also ask for explanation, take explanation, consider them in your report and file your report accordingly. Acceptance or rejection. So here it says you may, ask for fresh start, but since this has not been notified yet, so nobody has recommended this part as yet, fresh start. We always recommend for the PG to CD initiation, insolvency initiation. Obviously, you record your reasons. Once that report is filed, it's taken up. So normally we file it under IA. Personally, I feel there is no need to file an IA in such cases. If you are an advocate, you can file from your RPID. Simply file an application, a report. Let that report go to both the creditors, debtors, and if possible to IBBI also, and we'll put them through speed post. File it from your RPID. I think it should suffice. But most of the RPs are taking a decision that let it be filed by IA, spending another 1,000 rupees plus the cost for no reason. Once this is filed, now the AA has another document where some independent third party is recommending or rejecting. So it's like taking another legal opinion, right? So RP has
Neeraj ji, there is
given
one
his
issue.
opinion.
There is one issue here. When we are
Sir.
filing this report, is it mandatory that RP has to file? He cannot engage any lawyer, advocate to file?
That is also, sir, let me keep it for this India Bulls case. I genuinely want to keep it there.
Because recently,
Uh,
a principal bench NCLT objected that why
Yes.
RP is engaging a lawyer.
Yes, yes. Sir, if you are only a CA, how will you know the nuances of filing at NCLT?
Number one, I just want to be more clear on that. Where in the IPC or in any other law is restricted that any person who cannot engage a legal person to represent him.
No, it doesn't, sir.
So then,
It's only for the cost part they are saying that, why to engage a senior lawyer for such a small thing. It's only a report,
no,
which
no,
is,
not a senior lawyer. It's just
I'm just saying, sir, if
huh.
somebody, I don't know which case you're
But
talking about right now, but
very recently, principal bench NCLT Delhi objected to engagement of a lawyer. Why? Where is the RP should argue?
RP arguing is fine, sir, but how will RP file, go to court? If I'm saying, let's say if you're a CS and you're not well versed with the NCLT proceedings, your scrutiny itself will not get clear for months.
Because even a report itself will
Yes.
deal with the new number of debts the corporate debtor has taken over a
Yes.
period of 20 years, and so many legal documents have been executed.
Yes. Yes.
So
Bigger cases, yes.
So all corporate debtor, he is a personal guarantor to corporate debtor. So corporate
Yes.
debtor must have executed loan reassignment, execution, all those things must have happened. Settlement, OTS, you know. So
Correct.
and legal documentation, security. So how
Correct.
RP himself, suppose he needs help to get them legally examined, and the principal bench is objecting, to my surprise and disappointment.
Sir, it might be case specific, so it cannot be a general
No,
blanket.
without getting into the merit of the case, general abrupt statement.
No,
So I
no
just
comment on, no comment on my lord, sir, in a public forum.
I
What
just
to say?
wanted to know whether
Yes.
legally
No,
we
no, sir,
are.
it doesn't stop anywhere. You can,
Uh,
anybody can appoint anywhere.
yes, yes, that was my
It doesn't
submission.
stop. It
That
doesn't
was my
stop.
submission. Is there any
Yes.
IBC or a law where we are stopped from engaging? You know?
It's actually silent in this part. So when we'll be finishing it till 120, you will say it's silent on engagement of assistance. In bankruptcy trustee, there is a particular section where they say the person can appoint as required. That means the BT can appoint. Whereas here it's quite silent. Here they only say you are consultant to the person, to the PG. Let him make a report on this, present it to the COC, let them say yes or no, file it. That's all. So till now it is only yes or no. Okay. Till now it is yes or no. Till now so if you are an advocate, you really don't need another advocate to represent you in this case. But sir, for CA, CS, MBAs who are coming into this, uh, I guess it should be allowed. It should not be not allowed. Okay. So we'll move further. Post 99. This is the actual admission order. Section 100. A shall within 14 days from the date of submission, either admitting or rejecting, then they will take a decision. So it's not necessary that you have asked for rejection, they will reject it. Or you have asked for admission, they will do the admission. As Honorable Supreme Court also said, it is only a suggestion, it's only an opinion given by a third party, independent party, and the AA shall decide at this stage now. Where the AA admits an application, they will issue instruction for further negotiations, etc., and arrive at a payment. If they feel this is not correct, they want to reject it, and obviously they send it to everybody within 7 days, etc., etc. If it is rejected on the basis of the report submitted by the RP, then the application was made saying that, if suppose you say it is made with the intention to defraud the creditors or the resolution professional, the answers will be recorded and the person now can go for the bankruptcy straight away. No need of doing this in between. So if it is rejected due to some reason, due to say defrauding, then straight away bankruptcy can start. Normally, I'm yet to see that, where RPs give this kind of, recommendation that this is to defraud, etc. They say either admit or reject it. So normal answer there. Post this, now the interim moratorium goes away and the final moratorium starts. When the application is admitted, a moratorium shall commence in respect of all the debts and shall cease to have effect at the end of 180 days beginning with the date of admission. So 180 days is in CIRP period also, 180 days is here also. Fine. Normally in personal insolvency, we have not seen any extension, etc., happening. It's normally 180 days, it has to be finished. Or if there is an order on repayment plan under 114, whichever is earlier. So either it will finish on 180 day or 114 order, whatever happens earlier. Suppose you say, I'm ready to pay everything in 1 month. Within 1 month, this can go away, the moratorium will get. During moratorium period, any pending legal action or proceedings shall be deemed to have been stayed. Creditor shall not initiate any legal action. Debtor shall not transfer, alienate, encumber, or dispose of any of his assets or beneficial interest. So it's an embargo on that person also. Where an order admitting the application has been made in relation to a firm, it will be on every partner. And obviously, these will not apply to, so government keeps themselves out of it. And it's also not applicable on the financial regulator. So 101 is moratorium. 102 is how we do the publication. In CIRP, we do within 3 days. In personal insolvency, we do within AA shall issue a publish issue within 7 days. Here you get 4 more days. That's all. They gave 4 more days so that AA shall issue. But obviously, AA never issues. They always direct the RP to make this publication. But luckily, RP still gets 7 days. So we publish the notice within 7 days at the place of his residence, the person's residence. Okay, that we will be doing. And obviously, we give, so in CIRP, we give, I think, 14 days and up till 90 days now. Here we have 21 days for people to file the claims. So within 7 days, you publish, 21 days, you will invite the claims, right? So 1 month going into this. Notice under this shall include detail of the order. I'm sure these are not that important. Your particulars, last date of submission. It's a pretty standard format these days. 1 English, 1 vernacular, daily morning newspaper, you have to give it. It says you have fixed in the premise of the AA and you place it on the website of AA. Unluckily, this is also not so this is on the website of AA, not the board. See, board has a website where we publish for CIRP. For personal insolvency, we still do not have any platform on the IBBI where we publish personal insolvency matters. It only says affixed in the premises. Now, how will an RP ensure that it is affixed on the premise of A? So what we do is we send a letter with a notice, same notice, we can forward it to the registrar. If they want to put it on the the place, they can put it. If they don't want to put it, I'm sure an RP might not be able to help much in this case. So our job is this: 1 English, 1 vernacular daily, that's all. Registering of claims by creditors. Creditors shall register with the RP exactly like CIRP proceedings through electronic means, courier, speed post, register letter, any which ways they can send. And if RP says kindly give other information, additional information, that also needs to be given by the creditor. Because see, this is a personal insolvency. Most of the information is not available in public domain. Maybe one creditor is more privy to some information. So if they have that kind of information which is not available in general public, but is important to carry out the personal insolvency, this creditor should give information about the person. Now, here it just says should, shall, right? So, but depends on the creditor. They may say we were not privy to this information. Similarly, in CIRP, we prepare list of creditors. List of creditor is based on the information disclosed in 94-95 or as per the claims received by 102 after the publication of notice, right? Now, RP shall prepare the list within 30 days. So we have already spent 28 days there. We have 2 more days to collect these claims and make this list. Once this list is ready, a repayment plan stage comes. Now, till now, we are assuming the person is participating and is ready to give the repayment plan. He or she, right? The personal guarantor. The debtor shall prepare, in consultation with the RP, a repayment plan containing a proposal to the creditor for restructuring his debt. Normally, restructuring means reducing, right? But restructuring not necessarily mean reducing. If the person is doing very well, he's only expecting maybe in 6 months' time, everything will be settled, everything will be fine. he may restructure it. So restructuring not necessarily mean reducing or haircut or any such thing. But yes, in common parlance, we know restructuring means you cut it down, right? A repayment plan may authorize or require the RP to carry on the debtor's business or trade on his behalf, realize the assets of the debtor, or administer or dispose. This will only happen in case the person is totally incapable, or maybe not in the country, or something is happening, they may allow. Otherwise, nobody allows an RP to, take over their own assets. But law allows it. Repayment plan shall include the following. So these are three important things which needs to be included in the repayment plan by the personal guarantor. Hence, there is no set format. There is no set format for repayment plan. I have received a repayment plan of 2 page only. And some people give 10 pages also, whatever they want to write. So end of the day, there is no format. We have to develop our own format as an RPs. Repayment plan shall include the following: justification for preparation of such a repayment plan and reasons on the basis of which the creditor may agree upon the plan. So plan is one thing. He has to tell what are the reasons. Suppose he say, I do not have anything. Everything. Suppose he was a carpenter, he was a painter. I'm just giving a very different example. Suppose he's a painter, all his hands is, let's say his hand is no more there, right? He met in an accident. He cannot make further paintings. How can you expect the same person to earn the similar kind of earnings in future? So he will give a reason that why now they should agree to this plan, because of the peculiar situation the personal guarantor is in. So what is the plan? First, justification, and on what basis he believes the COC will agree on this. Three things. It will also talk about provision of payment of fees to the RP. Unluckily, so far, nobody has discussed about the fees of RP. Who fixes it, when it doesn't fixes. So if RP asks for fees, he will ask for replacement, isn't it? So that we need to check. We need to, be little considerate here. We don't ask for exorbitant fees or anything. But there is no set formula on fixing the fees. In CIRP, luckily, we now have some minimum fees criteria. In personal insolvency, it is still not there.
Rana
Oh.
ji, just 1 minute.
Sir.
The
Sir.
example of the painter may not be applicable here because the painter might not have given a corporate guarantee.
Sir, I just gave you an example to say that his
No,
situation
I'm just
might.
saying my
Yes.
submission is to, because there is some repayment plan where the personal guarantor is submitting a repayment plan in any format, because there is no format, and he's saying that he doesn't have any asset, he doesn't have any future income also. And whereas when he has taken the loan, he had fair amount of net worth certificate on the basis of which the personal guarantee was accepted. So the NCLT is asking RP, why, on what basis, this personal guarantor is saying that he has no asset, no income, how the loans were granted. So what RP has a ground to explain. RP was not party when the loans were disbursed.
Absolutely, sir.
So what is the way out in that?
I'll tell you, sir. I'll tell you, sir. So in this case, RP is not preparing the plan. RP is only giving him consultation. This is a plan given by the person himself herself, right? He has to give the reason on which, see, I've highlighted it. The creditors may agree. It does not mean that they have to agree. It's an option. He has to reasonably convince. If the judges are not convinced, whose money is not at stake, how will the bankers will agree whose money is at stake? So he has to give a realistic plan. If people know that he's driving Ferraris and Lamborghinis and he's saying, I have only 1 lakh rupees to spare, nobody will agree to it. So that what you have asked is, RP does not have a consultative part in this. RP will not say that, sir, you keep enjoying your life and just put 1 lakh rupees. RP is not asking that. RP is only saying whatever best you can do realistically, which any person with common knowledge and intelligence will agree, offer that plan.
I agree with you. I agree. There are two issues. Number one, NCLT is asking, I may not know what kind of personal life, suppose I know, I may not know unofficially what kind of personal life he is leading and what personal assets he has. Okay. But he
Yeah.
in the report, he is in the repayment plan is saying that he doesn't have any asset, he doesn't have any future income. And I am presenting that to NCLT. Now, how I can reply to NCLT, why the personal guarantor is not disclosing all the assets, all the income which he had at the time of taking loan? That is my question.
Sir, how can you do it? An
Ah,
RP cannot do it, right? You are
no,
not
that
an
is my order.
investigative agency. No,
Ah,
you are not an investigative agency. And the person might have been a big person at that time when he took the loan. If he was the same person today, obviously there is no default.
but
The
NCLT has
default has
given
happened.
again a direction to me that you give him an opportunity, you explain him, guide him, persuade him to come out with a better repayment plan, which I have done,
It does happen, sir.
which I have
So
done to the best of my ability, which I have done. So is it advisable for me to make bank as a party in my hearing? Let bank explain on what basis they gave loan. Because NCLT is asking me कि crores of rupees were dispersed and now you say he doesn't have anything. Where is the money gone?
So, sir, best thing you can do is, Mr. Rajiv is saying something.
Yeah.
Okay.
We were
So,
debating internally. So yesterday we
yes.
thought we should make bank as a party. So I thought today I will seek your advice also.
So when you make a party means it's in front of the court. Instead of
Yeah.
that, as an RP, as an officer of the court, you can make a common email to both of them asking that this is the question put up from the honorable court to me,
Okay.
which is non-justifiable, because at that time, if the situations were so good, let the person explain how the situation has deteriorated. See, situation cannot deteriorate in one day. It has to go gradually. He will tell the sequence of events. This is the day when this one died. This is the situation when he suffered loss in horse trading. Let him give that reasons. If those reasons are digestible and if the bank is also agreeing to it, Honorable NCLT does not have anything to do with it because it's a commercial wisdom then.
And incidentally, Devratji, the banks are not coming with a straightforward reply. They are rather telling RP, you suggest us what should we do?
Sir, you are telling, no, you are asking the person to give a stage-wise reply that what happened in your life.
Yeah.
Suppose I'm giving in just a,
Understood.
we are
Understood.
little diverging,
Understood.
but I hope it's
Understood.
have
Understood.
that, you
Understood.
know, 2010, 2011, what
Understood.
happened to like that.
Now we can
If
tell him
that
to
comes up,
we can tell him to give detail. If he gives, okay. If he doesn't give, I can't force
if he
him. Na.
still can't give, what can you do, sir?
Yes.
This is only
Understood.
consultative, no
So
coerciveness right
so
now.
there is no need to make bank as a party to
No
NCLT.
need, sir. No need. It will
That's
take
it.
you another 4 months, sir. It will take you
Because
another 4 months
the
to.
bank is asking how the loans were dispersed. I can't answer those questions. So let bank
Sir,
explain why they did
co-
why they accepted the personal guarantee of the person who has nothing.
maybe if you want, you can do a COC kind of thing, in
Before
this.
submitting.
No, you're still at the stage of recommending.
No,
I
we have
mean, this one.
submitted thereafter in the argument. We have submitted the report.
You have submitted. No, so you can do it. What's wrong in that?
We have submitted the repayment plan.
You
Then
can
bank,
ask, let them come, sir. See, you are still officer of the court. You are trying to mediate. Now,
yes.
mediation is coming in everything. Mediation is coming even in IBC. You are only trying to help them. If they are not replying on emails, invite them. If they're still not coming, then you have another reason to say, I invited to connect everybody. Nobody is coming forward. What can an RP do in that case?
So to conclude your advice, I should, before I submit the revised repayment plan, which the personal guarantor has given, I should take bank into confidence. That's all. This is the plan I have got.
Try take both of them in confidence. And in my personal view, I believe if they can meet with your support, does not hurt. It does
Okay.
not hurt anybody.
Okay, let me. It be. I should organize. I should try to organize a meeting where
If
both of them
possible,
can
why
sit.
not?
Okay.
Yes, yes,
Thank you.
yes.
Thank you.
We'll move to 10. Okay, 105 we have finished. 106 is the report on the repayment plan. So this is the one which Anilji was talking about. RP shall submit the repayment plan under 105 along with his report on such plan to the AA within a period of 21 days from the last date of submission of claims. So last date of submission of claim was 28 days. Remember, 7 days plus 21. From 21, you had 3 days to collate those claims. And from that, you have around 10 days for the repayment plan from the person and another 7 days to submit it. So within 2 months' time, this process should be over, entire process. Report referred in section 1 shall include repayment plan in compliance. Repayment plan has reasonable prospect. Now, this is a problem for the RP. How will an RP says that this repayment plan has a reasonable prospect of being improved? This is a gray area which just now we were talking about. There is a necessity. He will also have to say there is a necessity of summoning a meeting of the creditor if required to consider the repayment plan. Right? Suppose the repayment plan is so bad, RP says that this is ridiculous. No need of summoning the COC. So this was allowed earlier. Now the new regulation says in every case RP has to summon the COC. New regulations recently in February, I think, says RP now has to necessarily summon meeting of the creditors post this. If required to consider, provided where RP recommends that a meeting is not required to be summoned, reasons for the same shall be provided. Earlier we were giving reasons, now there is no reason. There can only be one reason now that no payment plan has come.
So meeting
Suppose
has
no
to be
payment.
necessarily called before
Yes.
submitting the plan.
No, sir. So report of the resolution professional on repayment plan. So this you have submitting. My question is whether regulation says you have to necessarily called.
Before submitting the repayment plan with NCLT.
No, sir. That was a report, sir.
No,
Now,
repayment plan I submit. Before I submit to the NCLT, I must call the meeting of creditors.
no, sir.
Acha.
Okay, please read it. Report referred in this shall include what? Repayment plan. Repayment plan has a reasonable prospect. And if there is a necessity to summon, you just have to tell whether I'll be calling the committee or not. Here you have to provide reason if you don't want to call it, why you don't want to call it. I hope you got it. So IBBI is saying do
Ranaji?
not. Yes, sir.
Ranaji, what if
Yes,
there is no repayment plan?
good question, sir. This entire spectrum never talks about if there is no repayment plan. They have assumed that it will be there. Whereas in my first case, this happened, there was no repayment plan. He says, I'm not giving,
One
I'm
of my
preferring an.
the scenario is there.
Sir, it's a most common scenario, but that scenario is never discussed here. Nowhere it says. Because in commercial wisdom, in their wisdom, the parliament never thought that somebody will not put a plan. Because it's a great opportunity which PG is having. Why they don't put it? Because if they don't put it straight away, any which ways bankruptcy will start. So what is the fun of not putting a repayment plan? But that is the harsh truth
That is
which you also have faced and
yes.
everybody is facing. So they give one or the other reason. They'll say it's not admissible, it is not admitted, but they will never put a plan. Because when they put a plan, you have to give information and nobody wants to give information.
Okay.
Okay. So we'll move further, sir. 106 report on the it never says report of the resolution professional if no repayment plan. One section could have been added, right? But it is not there. So since it is not there, absence of repayment plan is also covered in this. No repayment plan. Please put that there is no necessity of summoning a creditors meeting because there is no repayment plan. When there is no repayment plan, straight away, whatever, dismiss this application and the creditors will have 90 days to file for bankruptcy if they want to.
Yes.
Okay. The date on which the meeting is to be held, whenever you are proposing, should not be less than 14 days and not more than 28 days from the date of summoning. So in CIRP, your time period is 5 days, right? To summon, minimum 5 days. Here, minimum is 14 days. You have to give for them to come to a table. I don't know why 14 days is done, but some wisdom must have said that it should not be held less than 14 days and not more than 28 days from the submission. I am assuming it must be considering that NCLT might take that much time to consider it. So that opinion you might receive it before the meeting, before the committee. So maybe that is the reason. But we have 14 minimum and 28. Between that, we have to do a COC meeting for this. RP shall consider the convenience of creditors in fixing the date and venue of the meeting of the creditors, right? Another, I don't know why we need to write it because RPs will obviously consider the conveniences, right? Okay.
Well,
Sir,
what about the convenience of RP?
I will not say that, sir. So 107, I'll move on to summoning of meeting of the creditors. RP shall issue a notice calling the meeting of the creditors at least 14 days before the date. RP shall send a notice to all, shall state the address of the authority to which repayment plan on this has been submitted. Also accompanied by copy of repayment plan, copy of statement of affairs, copy of that said report of the RP, forms of proxy meeting. Proxy meeting, including electronic voting, shall take place in such manner and form as may be prescribed. Here also they want voting, electronic proxy voting. It
No.
costs money. People are
Now,
not ready to put money, but yes, sir. Yes, sir.
the one question here. Who are the creditors here? There are creditors who have
Everybody,
submitted the
sir.
claim. There are
Everybody, sir.
creditors. No, there are creditors who have submitted the claim. But there are
Yes,
creditors which appear in the repayment plan by the PG.
yes, yes. Those also, sir. Those also, sir.
Well,
100%.
am I supposed to verify those claims also?
Okay. Very good question, sir. So CIRP and this is different at this aspect.
Yes.
In CIRP, somebody who has not submitted the claim, his claim vanishes. But in personal insolvency, somebody who has not submitted the claim, that person's claim does not vanish. The person himself is saying, I owe this debt to this X person. Obviously, you will issue. But suppose that person is not submitting claim, he is a related party, he will any which ways will not have any voting rights here. So in sharing information is not a crime, sir. If the person in his repayment plan saying I owe X money to X person, why will you not inform that person that we are taking a decision on it?
No, Ranaji, my question is different. I invited through public announcement claims. I received some
Yes.
claims which I have
Yes.
verified and admitted. Now,
Agreed.
after a marathon exercise, I get some repayment plan. In the
Yes.
repayment plan, the personal guarantor makes a mention of hundreds of other liabilities.
Correct.
So now, what is am I supposed to verify all of them? Because they have not claimed, and he is not
No,
submitting all the documents also. Then the process will be late. Because he
sir,
says
sir,
he
sir.
owes this much money to these 100 people. Am
I
I
got your
supposed to
point, sir.
verify and
Yes, sir.
admit and then make a COC? That is my question, sir.
No, sir. I never said you have to, it's your obligation to admit. The person who is saying that this liability is there has to prove it. Proof, the burden of proof is on the claimant.
So the person has
In
not come to me.
Sir, I'm coming there, sir. I'm coming there. Wait.
Yeah, yeah.
So that person has not come. Somebody has told you. That somebody is the personal guarantor himself.
Yeah, yeah.
Correct?
Yeah.
Now, it is duty of the personal guarantor to prove that debt. If he is not able to prove that debt, then obviously that liability is not there. You
So
keep it as a contingent. You keep it as a contingent because see, end of the day, sir, you please have to understand this process is not coercive. This is personal. The person knows who he owns to. Suppose he says, my driver, I own this much money. The driver might not be reading your newspaper or your AA website. He is
Agreed.
telling that, okay, I owe him.
I
But
agreed.
if he owes him, let him inform it. And if his and that debt can only be washed off if it is mentioned in the repayment plan. If it is not mentioned in the repayment plan, there is no section 32A here. There is no escaping the liability if it is not mentioned in the repayment plan.
No,
So
no.
that repayment plan has to be there. Repayment plan has to inform the person if you want that liability to go away. If
No,
that liability, yes.
my question remains that am I supposed to verify those claims, those
How
creditors?
will you verify if you don't have documents?
No, if I ask him if I have a duty to verification, I will ask personal guarantor to provide the document. If I am not bound to verify, I will accept on the face of it.
No, sir.
That is
Sir,
what I
you
want to
are,
know.
no, sir. You have to verify because try to understand the implication of it.
Yeah.
Suppose there are only 3 people who have claimed, whereas he owes money to 100 people, other
Yes.
people.
Yes.
If you consider only 3, this repayment plan will only be successful with respect to these 3 people. His liability will still remain standing for 100 people. After 12 months, they will come back after his life.
No, he is mentioning those 100 liabilities in the
When he's
repayment
mentioning, he
plan.
has to prove it
So I have to go for the verification of those liabilities or not?
with the documents. Yes,
Yes,
that
that is
is what
my
I'm saying.
question, sir.
Yes, sir, it is your duty, sir.
Uh-huh.
And since you have to go to verify 100, obviously your fees will be commensurate with that. Verifying 3 claims versus verifying 100 claims is two different things,
So
right?
all of a sudden he has come with a big list of the claims in the repayment plan.
Sir,
So
let him
far there were
give
no
the
claims.
proof also. Let him give
In
the
my
proof
view,
also.
sir,
Yes,
in my view, if
yes.
this application is under section 94 and the creditor is filing it himself and he in the application he has mentioned all the creditors, so RP has to take it that way. Whether the claim
It's
have been filed after this notice or
Sir,
not,
Anil ji is
has to
talking about
include it in
95,
the
sir.
list
I'm
of
sure.
95,
creditors.
95.
Yes. Sir,
Here
normally
the
this worry does not happen in 94. 94 they have to give, they want to admit it. So they will give all
Hmm.
the detail. This trouble happens in 95 because they have 7 days and they will give all this big list on 7th day. How will the person, how will the
now
RP consider?
my concern is to verify all those 100 small
But I don't think RP has to verify that. If the
Sir,
list
right
is being
now,
given by
yes.
the debtor himself, so he can take because he is owing that I have to pay this much. I owe this
that is
much.
Sir,
Dev ji, that
admitted,
Where is the need to verify that?
Anil sir, when we say no, admitted facts need not be proved. Correct. Admitted
Yes.
facts need not be proved in the court of law. The person himself is admitting that I owe this much money to this person. Now only, see, Gurudev ji, Anil ji was asking it so that,
Yes.
he will not make the claim so big. He will show you 100 people with 1 crore each. And then the bank's, voting share reduces to nil. So maybe that is the concern which is coming here. But if he's admitting, sir, let him prove it also why it is due. If
I
it
think
is due, then why not?
Rana ji, this is a very relevant gray area whether I am
Yes.
supposed to verify each claim and admit and make a part of COC, because in that case the process will become very long. Well, he may owe because he may owe people still are
Sir,
10 years, 15 years. Legal
sir,
cases are going on.
sir, PG knows how to delay the process, sir.
No. So we should know our duty, what extent we have to verify.
Sir, where it says you don't have to verify, it says you have to verify and collate every claim. RP job is actually only one,
But
collating the claim.
claim received against the public announcement.
No, 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 sir. It never said that.
Claim
Sorry.
received. See
No,
104,
no, no,
right?
no.
Read 104.
No, 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 no. It's not
Section
necessary. He may have.
104.
Sir, sir. Okay, I'll come back to that.
Yeah.
So, RP shall prepare list of creditors on the basis of information disclosed in the application in 94-95.
Yes.
Claims received by the RP under 102.
2.
Right?
I have not received the claim. I
Yes,
have
sir.
not
So then
received the
Some,
in application.
sir, somebody is admitting, no, what is, so that is as good as information in
No,
94
no,
or
no, sir.
95.
The law is saying the claim received by RP against my public announcement. So am I supposed to verify those claims which are not received by me? My submission, my request to know is that I want to get clarity on that, sir.
But sir, what is the problem in accepting it other than time consuming thing?
You told yourself the ratio of the creditors, and the secured creditor will get
Agreed,
distorted,
agreed, 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 sir.
and the process of verification will be very time consuming. There can be
Sir,
disputed claims,
that,
contingent
oh
claims.
yes, yes, yes. They are mostly they are contingent claims.
So
So you keep them,
I
sir.
cannot be passing judgment on that.
No,
I
I'm
will be
giving
getting
you
into
an
controversy.
I'm giving you a simple solution. Let me try.
Yeah.
Why don't you keep them as contingent claims till they are proved to you?
He
Keep
say
them as
he will say
contingent
PG will say
claims.
I am ready to give you all documents. Take the documents.
Okay,
Verify.
keep giving, keep giving. What
Huh.
stops you from filing your report? Say this has also been sent by this person, and
Okay.
in COC you take it up. At the time of COC, before COC, you take it up.
But COC will consist of those creditors also. They are not admitted.
Unluckily, yes, sir, what you are saying is also right. And as you can see, section 104 is also silent on it. Now you
Yeah.
have to process, you go to that standard code of procedure, right? It says every claim needs to be collated properly, filed by the RP. How will you deny that? How will you say I'll not take a claim because somebody has not filed it against? Either you can ask them file directly to me, then you can check it up, or let him give in together. Sir, he might have 10 drivers. How will they file individually?
I think
So he might be
this law
giving
has
the
to
answer.
on this it has to get evolved.
We are still evolving this, sir.
Because
This law
PRP
is
is
still
new.
in a
Uh,
nascent. Yes, yes,
Yeah, it is
100% agree.
evolving every day.
yeah. No, CRP has evolved to large extent, but PRP
Yes,
just
yes, yes.
started.
The CIRP has taken
Definitely it
7
has to
years.
be.
This is only 6 months.
Yeah.
So we're still learning.
Yes. Yes. Yes.
Yes, carry on, carry on.
Thank you. So report we have done. Summoning of meeting we recently did. Now conduct of meeting. Conduct of meeting shall be conducted in accordance with the provisions which are coming in 109, 10, 11. In the meeting of creditors, creditor may decide to approve, modify, or reject. Now, as Anilji was saying, there is no secured creditor, unsecured creditor here, okay? In personal insolvency, security, non-security, OC, SC, FC, nothing. Creditor is a creditor, simple. And that is a worry part also at times, that where people want to cook up the claims. In the meeting of creditors, the creditor may decide to approve, modify, or reject. So everything is available here again, commercial wisdom. The RP shall ensure that if modifications are suggested, consent of the debtor shall be obtained for each modification. If there is any change in the repayment plan, it should be accepted by the debtor because end of the day he has to give the money. He has to accept it, right? RP may, for a sufficient cause, adjourn the meeting for a period of not more than 7 days. Fine. At a time. Huh? So they say always give 1 week time for them to consider, come back, give it up. So at a time, adjourn for 7 days. So in 1 month, you will do at least 3 COCs, right? 14, 7, 7. Now we come to the voting right. See, these are time, etc., thing, not so important. Whenever you get a case, I'm sure you will check it up also. Where is the voting right? This has to be clear on our IP's mind. A creditor shall be entitled to vote at every meeting of the creditor in respect of the repayment plan in accordance with the voting share. Same thing. RP shall determine the voting share to be assigned. Creditor shall not be entitled for an unliquidated damage. It has to be a clear X sum. If it is under litigation, under something, the voting cannot be assigned because that will depend on the outcome of the case. Creditor shall not be entitled to vote if he is not a creditor mentioned under exochar or if he is an associate of the debtor. So Anilji, if you put a report against this, then obviously he will lose the right to vote here. If you want to keep it separate as an RP, you can take a call, make a list as per 104 where voting will happen and all other claims will be there. Your call, sir. Right of secured creditors in relation to repayment plan. Now what happens to these?
Meaning thereby I will have two lists of creditors.
That is also one way of looking at it, sir. Yes. So one which is as per the claims where they have filed, their all the documents. Another one which was suggested by the uh, applicant, by the PG, and where you don't have documents or you are not able to confirm them as yet. That is also possible. That is another way of taking it up, sir. As we learned, we are still evolving. Let's see how the courts take a call on this.
கால் வரும் அதில் தான் கூப்பிடணும் அவரை.
But if they are included in the main list, then they will have a voting right.
இத்தனை பேர் பண்ணி காசே நடத்த விடாம பண்ணிட்டு இருக்கான்.
Nand Kumar ji, please keep silent. Amit ji, you also please. Amit Choraria. Okay. Right of secured creditors in relation to repayment plan. Now what happens is secured creditor shall be entitled to participate. A secured creditor participating in the meeting and voting in relation to the repayment plan has to forfeit his right to enforce the security during repayment plan. Then only he can vote. If he does not, then he will not be part of this any which ways. Whereas secured creditor does not forfeit his right to enforce the security, he shall submit an affidavit to the RP at the meeting saying that the right to vote exercise is only in respect of the unsecured part of debt. And what is the estimated value of the unsecured part? In case a secured creditor participates in the voting by submitting an affidavit that his secured part is this and unsecured part is this, it will be treated as separate. Concurrence of the secured creditor shall be obtained if he does not participate in the voting on repayment plan, but provision of the repayment plan affects his right. So though we say that voting right is not dependent on security, non-security, OC, FC, but if a secured creditor wants to be away from this process, he can opt to do so. There is nothing binding here.
One question, Rana ji here.
Sir.
This subsection, the 5 clause of this 110. So if in the repayment plan, the debtor has put this that I will be selling these assets which are already mortgaged to the secured creditor. So can this plan be conditional?
Sir, he cannot.
Or we can get it through the concurrence of that secured creditor.
Yes. If concurrence of secured creditor is there, then no problem, no, sir.
Can a debtor put a repayment plan saying that I will be selling the assets which are already mortgaged with the secured creditor
Sir, that
without his
asset has
consent.
already gone. So what is there to put in a repayment plan?
No. The personal asset. The asset in the name of personal asset, this personal name,
Sir, security is only
that is
about personal
mortgaged to that
assets.
secured creditor.
No. Secured creditor is also the personal assets only we are talking about, sir. We are not
Yes.
talking about company assets. We are talking about
Yes,
his
we are talking
house,
this
let's say.
personal assets are there.
Suppose his house he has given on mortgage. He has taken
Hmm.
mortgage against it, or LAP is there
Hmm.
or something. Now that person is secured. How can he be dragged into the PIRP process? Not possible. So if security is
So before,
already
by
gone, it's
concurrence,
already
we
gone.
can go for it. Because if
Oh
it is,
yes, sir.
if we want to do it, we have to have the prior consent of this.
Sir, if two people
Otherwise,
are
it will be a
ready,
conditional plan.
if two people are ready, nobody can stop it, right? But the other person has to agree. So
Hmm.
concurrence of the secured creditor, if it is obtained, then otherwise
Ranaji,
it's not possible.
No,
Yes,
but
I
it says concurrence of the secured creditor shall be obtained if he does not participate in the voting.
yes, he is not participating. No, here,
Yes, he is not
secured
participating.
credit. He is only participating regarding
But
his unsecured debt.
yes, but
He may
the
choose
provision
not
of
to participate.
the provision of the repayment plan is affecting his right over that asset.
In that case, you need here, if it's affecting him, here, if it affects, you need his concurrence.
So it should be prior, or otherwise we can put it through repayment plan.
No, obviously in repayment plan, sir. In repayment, where will you take his concurrence? You will take only in COC,
It
right?
can be, it can be in two ways. Because first we can have it discussions with the secured creditor that you relinquish your
Uh,
right.
if
One thing
sir,
is that.
if you have
But
pre-approvals
if
from
he is not
somebody,
doing
then
it,
nothing like it. If you have pre-approval,
yes,
then nothing like it, right?
relinquish,
You
yes.
will
If he is
plus
relinquishing his
plus
right,
plus
then it is fine. But he
plus
is not
try
doing
to
it.
sir, try to understand. He is not doing it
Mhm.
earlier. Obviously, he will not do the same in the resolution plan COC also, right? It will fail.
Definitely. My question is, if the debtor puts this in the repayment plan, will it be treated as conditional?
no, it is not conditional.
The repayment
It
plans are all conditional. What stops it from that?
it has to be implemented over a
That
period
can
of
be.
time, na.
Every plan is
That can be.
discussable now. There is no fixed final plan. Every plan it can be discussed. When you're discussing, that
Yes.
means it's not binding. That means it is conditional. That means it's changeable. This, even
No,
if you remember CIRP earlier days, we used to have, payment plans with security code and password protected, and you open only in front of, all the applicants. Now COC discussed plans 5 times, 10 times. It keeps going. Then where is the sanctity of putting in a bid and a
Yes, that
closed
way we can,
envelope and nothing?
that way we can take. Yes,
So
yes.
no,
here
Gurudev,
also it is an open plan. We are discussing. We are only discussing. We are not coercing somebody. We are discussing. This plan has come by. Do you agree? He says, I don't agree. You don't agree. Then the plan finishes. Go for
Yes,
bankruptcy straight away. What can we do?
Gurudev ji, another
yes,
thing. The point is
yes,
repayment plan period has to be mentioned. The plan will be executed over a period of time, and the
yes.
repayment will take place by selling the assets only. So that is not a condition at all. It is not a conditional plan.
No, sir.
It,
He
no,
said,
no.
you
He
will
will sell.
sell. No,
Ha.
you will sell only which is not unencumbered.
Yes,
If it is already
unencumbered, I
encumbered, then
can.
what can you do,
But
right?
if it is encumbered, then definitely I have to have concurrence of that secured creditor.
Correct.
100%, sir.
So
100%.
naturally
But
the
got that point, got that point, because the repayment plan is again conditional and it has to be to be discussed with the committee of creditors. So we can put
Absolutely.
anything what is in our mind, what is the mind in the mind of debtor.
Sir, I have changed 4 times one repayment plan.
Okay.
This person first offered 1 crore, then he offered 2.5 crore, then 3.5 crore, then 3.75. So everything is changeable, not to worry.
Acha,
And
Rana ji,
commercial wisdom of COC is now non-justiciable. Yes, sir.
Rana ji,
Mhm.
if the secured creditor does not forfeit, relinquish his right on the security asset, then the entire amount becomes unsecured claim.
Whose
No, then
entire
he is
amount, sir?
secured for the
Sir, his
he is
part.
secured for all
Suppose
the
I'll
No,
tell you.
no.
Okay. Or let me explain, Anil. Sir, this is a phone, 100 rupees. It costs 100 rupees. Against this, you have given me one stamp which is 80 rupees worth. Now my security is 80, but I have given you 100. So 80 is secured, 20 is not secured. I
No,
am
that I
saying
know.
80 I will, no, so let me finish, sir.
Ji,
So
ji.
80 I will do it on my own. You don't need to worry. I will do it. I am only voting against my 20 here.
No, he is forfeiting.
One.
He
So
is
if he's
giving.
forfeiting, yes. If he's
In that case,
forfeiting,
what happens? The
then
entire 100
entire,
becomes unsecured.
oh yes, sir. Then obviously, then only he can vote. Then it becomes part of the kitty.
Okay, the asset become part of the kitty.
Yes. And only, and
yes,
that is
yes.
why we always say, sir, that is why we always say, if I have exclusive charge on the stamp, which is 80 rupees, why should I come into the common swimming pool? I will not come. I will only come when I have second charge, third charge, seventh charge, subservient charge, all those charges where I
In
know I'm
that
not
asset
able
is not
to.
sellable easily.
Absolutely, sir. That is the time when this person allows that fine instead of getting into litigation, fighting it for 10 years.
Yes,
I am ready to
yes.
relinquish it. Allow me. Only then.
Only that.
If I have my own car, why should I go in a bus? It's like that.
Got it, sir.
Okay. Now let's go to 111. You
Sir,
will
sir,
find it. Yes,
sir,
one one.
sorry for interruption. You go to 110 subsection 4, please, sir.
Okay. Yes.
In case a secured creditor participates in the voting on the repayment plan by submitting an affidavit under subsection 3, the secured and unsecured parts of the debt shall be treated as a separate debts. Here, this entire process is dealing with the unsecured portion only. If the secured
Yes.
portion means that owner of the property or that creditor should give forfeiting or affidavit for that security. Here, that entire process is dealing with the unsecured debts only. Why it
Correct.
is now stated very clearly, it shall be treated as a separate debt. What is that, sir? Please, sir.
Sir, please read this also then.
The right to vote exercised by the secured creditor is only in respect of the unsecured part of the debt. Right to vote exercised by secured creditor is okay, sir. Yeah. Got the point.
What the point, sir? Good.
Unsecured part of the debt.
We are only talking about unsecured part. We are only
Okay,
talking
fine.
about unencumbered asset. We are only talking about excluded debts.
Okay.
Instead of other than excluded debts,
Okay, fine, sir.
right? If somebody already has a charge, it cannot come back here, right? That is not right. So if
Fine.
somebody was doing surfacing, now let us ask some real questions here. Real questions are, let's say the surfacing was going on. It has stayed due to the moratorium. Now what will happen? So do they wait till the process is over or do they not wait? Because they are secured, they are out of this, they have given affidavit, we want to exercise it separately. Can they, what will happen? Can they continue with the surfacing action? Anyone would like to contribute or we can go ahead? So in my view, let me put it, otherwise we'll not be able to complete our part. In my view, that action cannot take place till 180 days or till the repayment plan. Once that is over, they can continue with their surfacing action. Till
Fine.
then, it will be stopped as a moratorium part, right? So nobody will touch it, but they have to wait for some time. So it's again a Look, it appears like a delaying mechanism, but that is how it is. Okay, now 111, approval of repayment plan by creditors. Repayment plan or any modification to the plan shall be approved by a majority of more than 75. See, in CIRP also it was 75, if you remember in the early days. Now
Yes.
it is 66. Because there we are evolving it every day. We were fighting so many cases. Here, nobody has even touched it. Even IBBI is not even looking at it. So it is still kept at 3/4. Maybe it will change, soon. But right now, 3/4, 75% is the voting share, right? But it says present in person or by proxy and voting on the resolution in a meeting. So simple, 3/4 is more important. Just remember that. Report on the meeting of creditors. Now another report. So RP, I told you, right? RP has to give reports and reports. So here it's only report making mechanism. RP shall prepare a report of the meeting of the creditors on repayment plan. After this, the report shall contain whether the repayment plan was approved or rejected. If approved, the list of modifications. Gurdevji, you were asking, right? If whatever changes, it can be done here.
Yes,
Resolu-
yes.
Second, resolution which were proposed at the meeting and the discussions on this. List of creditors who were present or represented and the voting of each creditors. Such other information as the RP thinks appropriate to make to the A. Notice of decision taken at the meeting of creditors. RP shall provide a copy of the report of the meetings prepared under section, it should be 112. Our X is wrong in this case. It says section 99, but it should be 112. RP shall provide a copy. So whatever happened, you provide a copy to the debtor, to the creditors, including those who were not present. So voluminous exercise. So Anilji, in your case, it will go to even those 100 people. To all those who were not even present at the meeting and the AA, obviously. 114 is the last order where it says order of the AA on repayment plan. Adjudicating authority shall by an order approve or reject the plan on the basis of the report submitted by the RP under 112. Provided where a meeting is not summoned. See, here they are giving option, right? AA authority shall pass an order on the basis of the report prepared by the RP under 106. Why they say this? Because when 112 there is nothing, no repayment, then obviously they have to take a call on 106. Order approving the repayment plan may provide direction for implementation. It's similar to our CIRP order implement resolution approval, where the A is of the opinion that the repayment plan requires modification, it may direct the RP to reconvene. So they can also bounce it back to the COC to redo something. So that observation also we have to consider. So 114 is the order. 115 is effect of that order. What will be the effect? A has approved the repayment plan. It will take effect as if the debtor himself is giving. Now he cannot say after the approval, oh, I did not do this, I did not say this, you have imposed on me, nothing like this. It is binding on that person. It is also binding on the creditors mentioned in the repayment plan. So Anil Sahab, if those 100 people are not mentioned in your repayment plan, this order will not be binding on them. This is the problem where you cannot let them go. That
So
is why you have to add them.
we have to share the repayment plan to every claim stated in the repayment plan by the PG.
Sir, that was here. That
Yeah,
was here.
yeah.
That was here. This is the order. Order of AA will have effect only, is binding only on those creditors
No, no,
mentioned in the repayment plan.
yes.
That is why your trouble of leaving them 100 is bigger, because if you leave them, they will come back tomorrow. their their right is not getting extinguished. It will get extinguished only if you mention it here and AA passes an order.
Got it.
Where the AA rejects the repayment plan, creditor or the debtor are entitled to file an application for bankruptcy. Copy of the order passed by this shall be provided to the board, blah, 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 all that. Okay. Now they have given an order, copies you have circulated, everybody is aware. Fine. Now what will happen? How do you implement and supervise? So this is that monitoring committee which we have in CIRP, right? So same way, RP appointed under section 97 or under 98 shall supervise the implementation. So you are de facto monitoring committee. The RP may apply to the AA for directions if necessary. In relation to this, AA may issue direction to the RP on the basis of application. So this is our 19.2 application. I hope you got it. 19.2 and 60/5, where we go for directions from the Honorable Court that kindly tell this person to do this, kindly tell this person to do this. This is that section, 106/2. Now comes the completion of repayment plan. So you have done the monitoring. Hopefully everything is settled, all well. Now it coming to an
Just
completion.
1 minute. It means RP does not have any right to approach NCLT for giving direction to PG before the repayment plan is submitted? Only under the repayment plan?
Yes, sir.
Before that, he has no right?
No,
If the
sir.
PG is not cooperating, then he cannot approach NCLT.
No, sir. No, how can you approach NCLT saying, my lord, direct them to submit a repayment plan? Other than
He is
that, there
not
is no
responding.
cooperation required. What? So he's not responding, he's not responding. You say he's not giving repayment plan, submit your report in 106, story over.
That's all. Okay.
This
You
he
are
can
not
do
taking.
it through his
So-
reports.
So his duty is over
RP can do this only through reports.
to report. So his duty
Yes,
is over.
Anilji, you're right. You're right. I think his duty is over.
Because that is very important. Tomorrow,
This was a chance given to the PG, a last chance for him to come with clean hands. If he doesn't want to come out, why will you force this person? We will do force in bankruptcy. If he's not agreeing here, bankruptcy will talk to him. There, let him do what he thinks he can do. Bankruptcy, we can take care. There we have coercive powers. Here we do not have any such powers.
Here we
So
can
direction,
only report.
yes, you only report, sir. That's all. And report also saying what has happened. You are not asking direction. You are not seeking direction.
No,
Nothing.
nothing.
Just
He
inform
was
what is happening.
simply what is happening. Yes.
Absolutely. So 16162 is which comes in. Now comes the completion. Let's say things were rosy, everything settled, done. Now completion is RP shall within 14 days of the completion of the repayment plan forward to the person who are bound by the repayment plan. Bound means whoever was mentioned, right? A notice of the repayment plan has been fully implemented. Copy of the report of RP summarizing all receipts and all. You inform them and you apply it to AA. Suppose if you are not able to finish it, within that time, you also have to apply to AA to extend the time mentioned in not exceeding 7 days. This is only to extend 14 days. So to extend 7 days, you have to file an application, imagine, which takes at times 10 days to get scrutiny clear. You apply, but our law says that, we have to apply. So if you are delayed by any chance by more than 14 days, you have to file this application also. So reports are under 99, 102, 106, 11. After that, what was that? Who can tell me? 112. Right? All these
and 114.
reports. Yeah. So 114 is the order, sir. So
Yeah, that is order.
yes. After that, when you are doing implementation, you share all this with the people what you have done. So reporting is a lot. Here it's a lot of typing job. So people, at times really don't pay anything in this process. Personal insolvency, they say, oh, you only have to put a report. But it's not, you have to only put a report. There are hundreds of report which looks like, going. And suppose this person comes out with an innovative idea of putting 100 creditors, you will have to send, you need an army of people to do this. So please take your assignments carefully like that, okay? This was on completion of repayment plan. Suppose the plan is not completed, premature, okay? It comes to an end prematurely. Now, repayment plan shall be deemed to have come to an end prematurely if it has not been implemented as per the time mentioned. Also, where a repayment plan comes to an end prematurely, the RP shall again submit a report to the AA which says receipts and payment made, reasons for premature end, and the details of creditors whose claim has not been fully satisfied. And this fully satisfied not as per their total claim, but as per the repayment plan. After this, the AA shall pass an order on the basis of the report that it is not implemented. The debtor whose claims were not fully satisfied can only file the bankruptcy. Suppose they had to pay 100 rupees, only 90 has been paid, your 10 is not paid, you can still go for the bankruptcy. So whatever was mentioned, if it was binding on one, it is binding on everybody. Failure, natural outcome is bankruptcy. Only difference is in CIRP, if the CIRP fails, next stage is liquidation. There is no gap. But in personal insolvency, if personal insolvency fails, bankruptcy is not naturally an
Not
outcome.
automatic.
You have to file under
File.
121, 122, 123, right? AA shall forward to the person bound by the repayment plan a copy of the report submitted, order passed. So obviously they will not forward it, only you will have to forward it. They will direct RP only to do this. So this again you have to do. AA shall forward a copy of the order passed to the board for the purpose of recording. You will have to do. Once this is done, let's say either it is premature or it is fully implemented or nothing has happened, your discharge order will come. On the basis of repayment plan, the RP shall apply to the AA for a discharge order in relation to the debt mentioned, and they may pass such a discharge order. The repayment plan may provide for early discharge or discharge on complete implementation. The discharge order shall be forwarded to the board for the purpose of recording. Discharge order shall not discharge any person. Order another shall not discharge any other person. Okay. Any other person cannot be discharged. Only the person who has presented the plan will be discharged. Obviously, standard of conduct is our SOP, SOC, which is do all the dealings at arm length basis. Don't be so pally, don't be enemy, all that things will come. And this concludes our personal insolvency sector. Rest is then the bankruptcy starts from 121 to, this is a lot longer section. I think last time I had covered it. Maybe next time we will check it up. But the IBC section is over. We'll go to the regulations once. Not too big regulations, only 13 pages. Anyone can tell how many pages is the CIRP regulations? Any
That
idea?
must have gone big.
100 pages, sir. Exactly 100.
But 1 million case loss.
That is certain. So I'm only talking about regulations. So
on
regulations is
each regulation,
100.
100 cases.
Yes, yes, that is also there. So in regulations, here we have only 13 pages, pretty small. We can run through it pretty fast. It says in exercise so and so, so and so. Short title, commencement, doesn't matter. This applies to insolvency process for personal guarantor to CD. Associate, again, in relation to creditor is associate, we have learnt up. Code is our code, CD, we know what is CD. Electronic means emails and email only, right? Form means forms appended, participant, RP, really doesn't matter. Resolution process commencement date. Now this commencement date is after section 100. So my one advice, I hope bankers are not here. Whenever RPs are taking assignments or they are bidding, please don't bid for that, your fees will start after resolution process commencement date. Keep some money in between for the report filing under 99, because that itself is a decent work, and nobody pays money before resolution process commencement date. So try to devise your bid accordingly, so that somebody is saying something.
Yes, sir. Actually, one of the case that was admitted yesterday, I think, this A has prescribed a fees for this section 99. We haven't
Where
asked
have
for
they?
it still.
Where have they?
Kolkata,
Where they
Kolkata.
have?
What is the fee they have prescribed?
75,000.
Sir, you are
For the
lucky,
entire
sir.
period. For the entire
I
period.
don't know. I thought that was the complete fees of the whole assignment. So I was afraid. Yesterday night, 10:30, I got the
So
this mail.
75,000 rupees is till the commencement of the PRP. Is it?
That's what.
Okay. Fair enough. Something is better than
Uh,
nothing.
one more question I wanted to ask, sir.
Sort this out. I want to show you one thing.
Rana ji,
My
even
last week case I will show you,
Rana
where
ji,
they never said such thing. You are lucky that if they gave that.
Rana ji, that advice
Yes.
you gave me personally also, but there is further addition to that advice. See, it is not only fixed sum which you should ask for the preparation of the report. Okay. But at times, this report gets discussed in NCLT hearing for several months
I
before the
know that, sir.
commencement starts. So you
You are
should
talking
ask
about
for
7 months, sir. We have lived 2.5 years.
so
One of
two
my
and a
case,
half
I
years.
told you, three
So
and a
you
half years we are
you
living.
cannot work 75,000 rupees for 2.5 years. How much it comes per month? So you should ask for monthly fee also.
I will show you, sir. I will show you, sir.
No,
Just now,
I am
one
just
of our
endorsing your advice, and I am giving further advice that the fee should be divided before the commencement of PRP into two portions. One for the preparation of report, the other for attending the hearing. Because
absolutely.
even the application has been filed under section 95 by the financial creditor. NCLT is always asking about RP. Where is RP?
Yes, now they are asking, sir, and you have to attend it every time.
So if you are attending a hearing, if you are preparing also for that, then you should be getting fee for that. That is my submission. So
Agreed, sir.
bid has to be revised now in three portions: preparation of a report, before commencement, and after commencement.
Agreed.
Yeah.
Amit ji, we were discussing.
One
You
more-
said 75.
yes.
Somebody has offered you on
Right.
17th of May. I got this case, Central Bank of
Mhm.
India. You can see. So and so, Mr. Rana has been appointed. We direct him to file a report. Nobody talks about any money, sir.
You have to claim. I think bank will give.
From where? From where? How
Bank.
much? How much?
That's what that you have to decide with the bank. I don't know how much they
No,
want to pay.
bank will say we did not appoint you.
I know. These people are very smart.
It's in front of you, sir. I'm showing you today's
Right.
case. I filed my report yesterday night.
Mhm.
This is what I filed yesterday night.
One more thing
What
I
to
wanted
do?
to ask you.
Yes.
I wanted to ask, like, say, I have this personal guarantor has 10 outstandings, and one person has claimed, and one person has filed the case, and nobody else has claimed anything, right? So in that case, only this one person's liability will be over, or like everybody's will be covered in this repayment plan.
Sir, just now we discussed it.
I know.
All those people who are mentioned in the repayment plan, they were aware, they were made aware, they were party, they were voting. Only those people will be aware.
Okay. Say tomorrow, if if somebody.
There is no section 32A, there is no clean slate principle here.
Okay.
There is
So
no
tomorrow
that
say.
if you are sleeping, you are sleeping on your right. No.
If
Here,
tomorrow
their
somebody else
right
wants to
does
come,
not. Yes,
he can
yes,
come.
they can come, sir. They can come, sir.
Even
Only
after.
thing is, it should not have happened within 12 months.
Okay.
Remember that in the beginning where we learned
Right.
only that part 12 within 12 months it should not have happened. If it
Anybody
happened within
can
12.
come later on and say that okay, I want to file a.
Certainly, sir. Certainly, yes.
Wow,
Certainly,
nice.
yes.
This is unique.
That is what we need to learn. That what are the different. See, CIRP you understand. I'm sure all of us understand. PIRP, which is personal insolvency, the differences we need to understand first. And that is why when you are advising the person, tell him not to hide. See,
Right.
that person might not have read a Jansatta where you publish the newspaper, right? Or, in a small corner you are putting it. How many people read newspaper? So but that person is your claimant. The PG at least knows about him, right? You know whom you have to give money, right? Or
Right.
who will be asking you, who's calling you every second day. Mention those people, tell them that please file claim. Even if you're not filing, I am giving information. I will include you. And I only need 75% voting to pass it through. So there you have an option to, remove them, but not mentioning, keeping them in dark, and you feel that you will sail through. No, that is not going to happen.
Got you. Very nice, sir. Very nice. Thank you so much.
75% of the people who were present in the
Who are
meeting
voting.
or who
No,
voted.
who are voting by presence or by proxy or anything.
Okay, 75% for every resolution, or there are two categories, 50%, 75%.
Sir,
Only
एक
one
ही है
category.
repayment, एक ही तो resolution है repayment.
There is no other resolution required.
What else? What else? I mean, okay, resolution can be this person may say, all these assets are here. Anil ji, you are my RP. I am giving you all the rights to dispose of and distribute it to them. I am going to Himalayas. He can do that. So that option is always there. So you may take a resolution on that from COC, whether they agree on this or not.
Again, 75%.
75. Sir, everywhere 75%. There is
75.
no. Here there is no withdrawal also. There is no 12A, nothing like that, sir. No 90%, simple majority, large majority, nothing. Simple 75, 3/4. That's all. Simple process.
Majority decision.
Majority. Okay. Resolution process cost may be interesting for all of us. It shall mean fees payable to the RP, expenses incurred by the RP for carrying out the resolution process, including the professionals engaged. Nowhere else it was mentioned that he can engage. We read the entire code, right? From 78 till 120. Have you ever seen any valuer appointment, any CA appointment, any accountant anywhere? No, nowhere it mentioned. Luckily, in regulations, it mentions including the fees of professionals engaged. So if you have engaged a lawyer, you can claim it here.
Thank God. If they would have omitted here also.
Absolutely, sir. That is why I'm saying, I don't know why principal bench is saying you should not do it. I don't know, maybe, fact of the case might be different, so we cannot comment, sir,
No,
right now.
our president sahab, he can say anything to anybody. He is my lord.
Is my lord, sir. But luckily, we have a respite. That resolution process cost in the definition itself says it includes the fees of the professionals engaged. Finances raised for the resolution plan and the cost. So this is that interim finance part, right? You can also engage that. Such other costs directly relatable to the resolution process to the extent approved or ratified. So here I assume the cost of proving the debt and verifying the debt. So as an individual, if you have 100 debts, how will you, do it? Or let's say you have to send speed post or courier to 100 people. Obviously, that itself will come to 10,000 something. So that can be included in this. That is your RP cost, RPC cost. Section, word expression doesn't matter. Eligibility, we all know there is only one eligibility. You or your partners in the IP should not be related to the person. That's all. And you should not be ineligible, like you haven't committed murder, you're a fit and proper person. Plus, please remember, AFA has to be valid on at every point. When you're giving AFA, that time also, when they're appointing also, your AFA has to be valid. If it is not valid, you are not eligible. That's it. So two things, please remember. Your partners are not related, you are not related. Second, your AFA is valid. The rest, everything can be taken care of. Obviously, written consent always goes in Form A, similar to CIRP. Here also we give Form A. This Form A, you also tell IBBI at IP1. IP1 is the form which you file at IBBI. That we have given the consent within 3 days of filing IP, within 3 days. Preservation of records, again, physical and soft copy needs to be mentioned. Here they haven't said 8 years and 3 years and all, but it only says that, as may be communicated by board. So since board says physical copy 3 years and electronic copy 8 years. If you don't want to keep them after 3 years, just send them to IBBI. Let them keep it wherever they want. Debt counseling. Debt counseling in relation to the RP resolution process may be provided by a guarantor by such person as may be recognized. You know who that person is. That person is the RP. Or maybe another IP, but right now it's only RP. Registration of claims, Anilji, this might be again important where your question was there. We're coming back. Submission of verification. Creditor shall submit its claim along with proof to the RP in Form B on or before the last date mentioned under Section 1.
Yes.
Creditor shall bear the costs relating to the submission, including proofs. Creditor may prove its claim on the basis of IU or any other document. RP may call other evidences to check. RP shall verify each claim as soon as it is received and prepare a list of creditors under this within 30 days. Where the amount claimed by a creditor is not precise, you can make a best estimate. Resolution professionals shall modify the amount of claim admitted, including the estimate, as soon as practical. As soon as practical, I think you may use this to your defense. If they were 100 and you are not able to, you can say it was not practical. After he comes across additional information warranting such revision till the approval of a repayment plan by the creditors. Claim dominated in foreign currency will be accordingly, doesn't really matter. Right?
So, Rana ji, it does not deal with the claims which are not received by RP. RP
But
has
you
to
have-
receive the claim in Form B.
Yes. So
Now,
that is one
my
way of looking
again,
at
my
it. Yes.
question comes to that. In the repayment plan, personal guarantor is giving list of 75 claims of different natures, of different timings. Some may pertain to, 7 years ago, 20 years ago, you know. So
So
now
the
what should I
beauty,
do with
one
that?
more
So
beauty you can say.
regulation is telling me not to consider them. As per regulation,
No,
I'm
no,
not.
where does it say do not consider?
So RP shall only consider in the Form
Where is
B.
only word? Where are you finding only? Where is the word only?
Acha. Only I have added na, to my
You have
defeat.
added. So that is your convenience. That is what I'm saying, sir. We are still at a nascent stage.
Huh.
RPs have to develop. This jurisprudence has to come from our side. When we will tell IBBI, we will tell ICSI, IPAs that this part is not mentioned. Let it also come into some regulation. Let some cutoff date come out of it so that there is a clarity on this. Till that time, it's your call, sir. You don't want to admit them, keep them as contingent claim. You say it is not practical to include, you say, okay, it's not practical. They have given you a leeway here as soon as practical. So you can use this to your advantage. But mentioning them, in my personal view, sir, this resolution is only successful when all of them are mentioned.
So can I
If
seek
they are not
direction from
mentioned,
NCLT, Ranaji?
what will you seek, sir? It will take 3 months to get a
Let them take,
direction.
because I should have clarity, because 75 claims, 100 claims which are mentioned in the repayment plan, what should I do with them? Because they will require time. You, as you rightly said, those claims, may be very pretty old claims. I, in order to verify them, I need to get into details and the documents.
Yes, you're right. Sir,
So,
till that time, don't give them voting rights. What's wrong?
and
Simple, no?
I tell,
Let them.
I request NCLT to give me a direction. How should I deal with them? Because regulation is silent on that. Code is silent on that.
I doubt, sir, they will give any direction. They can only tell IBBI to frame
Huh?
directions on this
Let them give
behalf.
direction to
Yes,
IBPI.
yes.
Yeah.
Fair enough.
So that
Maybe
I am
that's.
clear what should I do or what I should not do.
No, it's good for everybody, sir. If you will get these directions, all RPs will be
Because
thankful.
if I do, the
Why?
secured creditors will tell me, why are you considering all these claims? If I do not do, personal creditor will get annoyed. Please consider all my claims. So there is a
Sir,
dilemma.
uh, yes, you are right, sir. I agree on you
Ah,
because most of the time they consider themselves on the different parts,
ah.
whereas they supposed to be one at this stage where they're resolving. But yes, unluckily,
Because
if
if I
you
consider,
don't listen to FC, they will change you. If you don't listen to this person, he will change you. So yes,
so we have to be
agree.
careful. No, because secured creditor will not like the ratio to get disturbed. If I admit
Yes,
all those
yes,
claims,
yes.
75% at times may happen that it may shift to secured creditor to unsecured creditor. You know,
Agreed, sir.
so they may not be in a position to do anything.
Agreed, sir.
So that is my dilemma, sir.
But sir, if this happens, normally the PG is at the receiving end, sir. PG is at the receiving end because his plan will not get passed. Since his plan is not getting passed, he is again threatened with the bankruptcy. That is what he should be avoiding. He should try to not get into that tussle. And that
So
is why this last opportunity they should utilize.
PG already has been facing economic distress and challenges in life. He will face another one. But as a RP, you have to discharge your duty. You know, P,
Fair enough, sir.
PG is a big player, small or big.
I agree. I
He may be
agree,
small
sir.
person or big person, but he knows what he is doing. You know, but
Correct, sir.
legal responsibility now under IBC is with the RP.
Absolutely.
PG was always free.
Fine. We'll move on to the next transfer of debt due to creditors. Where a creditor assigns or transfer the debt during the resolution process, both parties share. So transferring is allowed, right? That's all you need to remember. Whenever it happens, you notify each creditor and the AA of any resultant change in the list of creditors within 2 days. Now, I don't know how you do this, okay? But law says that within 2 days, you inform everybody. I think the only way to do this within 2 days is get the thing linked in your account as an RP account, and then you can inform it within no time. Then it takes only 5 minutes. But if you go through advocate and advocate has to file IA kind of stuff, then it will take time. Otherwise, straight away you can file on the AA website, NCLT website. List of creditors again. The list of creditors prepared under section 104 shall contain the name of the creditors, amount claimed, amount admitted, security interest, if any, in respect of this claim. RP shall make the list of creditor available for inspection by the person who submitted claims. So one person who has submitted claim can check entire list, entire list. Serve a copy of the list to the guarantor. This you have to give. Make available the list of creditor on the website, if any of the guarantor. Present the list of creditors at the meeting of creditors. File a certified copy of the list of creditor with the AA along with the repayment plan. Statement of affairs. The resolution professional shall prepare a statement of affairs of the guarantor for the purposes of clause B of subsection 3 of section 107. Okay, so statement of affairs. Statement of affairs is the affairs of the person. He will tell. So as we were discussing in the beginning, the person has to tell how his life has changed over the years. He will tell what is going on. He will tell you about the assets and liabilities for the preceding 3 years. He will tell you details of the excluded assets and excluded debts, income statements for the past 3 years and current year, income tax return filed by guarantor. So when A asked that, 10 years back you had given this loan, that time you gave 100 crore, what has happened? Unluckily, the law says that he only needs to tell you 3 years, what has happened in 3 years. And 3 years, they always file zero return. Income tax return filed by guarantor preceding fine. And they say, if any, income tax return filed by the guarantor, if any, for the preceding 3 financial years. And many a times we come across, they say we never filed it because our income is below 2 lakh, 3 lakh rupees, and we don't need to file income tax. Creditor wise amount due broken up into secured, unsecured debt for the last 3 years.
No,
Detail
here
of debt.
Ranaji, one question. He says he
Sir.
has not filed return for last 3 years.
Yes,
Now, in the repayment plan, he is showing future income
right,
and he will have that income.
right,
And that kind of income he did not have in the preceding years. And I have to
correct,
comment upon the feasibility of the plan
correct.
now.
So you comment based on the why he's saying that, whether he has secured some, whether maybe last 3 years he did his new MBA or he cleared his CA exam. Maybe now he says, okay, last 3 years I was dead, but now onwards I can do it. My situation has changed. Obviously, you will take it up. Or let's say he has secured a letter from another big company saying, okay, so you give us consultancy. You have all those.
It's an enormous responsibility. Sharing the list of creditors to all the creditors, every creditor. Now 100 creditors are there. They can inspect,
It is, and that is why I always tell RPs, please don't accept assignments at 10,000, 15,000. Don't do that.
You require
It's
1% of 25,000 to uh, allow these activities to happen,
minimum, sir, minimum.
Uh,
Okay. Now, details of debt owned by guarantor and to his associate for last 3 years. Guarantees given in relation. So see, you said that he has given you. He has given you the detail of debt owned by the guarantor to his associates. So he's giving you that information. How will you not consider that? You will have to consider them. Details of the financial statement of the business owned by the partner or firm doesn't really matter. So the regulation goes till 3 years. They don't go beyond that right now. Now,
see,
meeting of the creditors and voting. Creditor who is included in the list of creditors shall be entitled to participate. Voting share shall be in proportional to the debt owned. RP shall convene first meeting within, you remember, right? 28 days. So 7 days plus so and so. By giving such notice to the other participant as decided by the creditor, which shall not be 48 hours. RP shall convene a meeting of the creditors on request of creditors having 33%, which is standard like CIRP only. Notice shall be served to every participant at the address provided to the RP in accordance with Regulation 12. Content, unless otherwise provided in the code, any decision of the creditors shall require approval of unless otherwise provided. So here now they are saying 50% is also there. Any decision of the creditor, a regular decision. For approval of repayment plan, it requires 75. So what I take it from here is any cost has to be approved. Let it be approved by 50%. Let's say you are hiring lawyers, accountants, or support staff. That kind of thing will go into 50%, and approval of repayment plan will require 75%. Content of the notice, I don't think you need to read it. Whenever you are preparing a notice, please, just go through them that, you have to write venue, you have to write time, date, etc. Who all are coming, whether they can come by Zoom meeting, video conferencing, how they can come, plus how can they cast the vote, whether they can cast in person, proxy, electronic means. If you are providing e-voting platform, etc., that can be mentioned in the contents of the notice. Notice shall also include agenda, list of matters to be discussed, list of issues to be voted upon, and relevant documents in relation to that. If an option to attend is through video conferencing, then you shall state the process, login ID, password, etc., etc. If an option to cast by electronic means, then you have to tell all these. So these 100 people, let's say if you are giving them voting rights, obviously you cannot ask them to vote in the meeting. You will have to then again provide for
E-voting.
electronic e-voting, and e-voting again will take 2 days to set up, and then somebody has to collate them, software usage, another 10-15,000 cost will be there. All these needs to be approved.
And some
And I
of the
think,
some of the claimant may not have email ID also.
sir, many of them don't have. Many of them don't. So whoever is voting, you have to consider them.
No, but those who do not have email ID, we send them letter to speed for how they will vote.
They have to ensure that they come to your COC meeting. And unluckily, if you take half votings at the COC and half of them does it in electronics voting, IBBI will also be after our life that why are we doing two things?
No, I have
Half
to
of the
organize one.
result
Nah, I have to organize e-voting, either physical
Absolutely.
voting or e-voting.
Absolutely,
And
sir.
calling
That is why
100
I'm
people
saying.
for physical voting is not easy.
No, practically it is very difficult, sir. And let's say 50 of them don't have email votes, then what can you do?
What should
So,
I do?
sir, there is an option for this. I'll tell you. But again, we might have problem in that also. In one of my COC meetings, I had I had a chit fund case. And those chit fund people also had similar thing that, they used to go to a cyber cafe for voting. They never had any email ID, no laptop, nothing. So, and many of them does not have any email ID.
Yes.
So I tried to do, send them links through their registered mobile number. And from the registered mobile number, they can get a link and where they can click. Now, this problem I thought is solved. But my problem was much bigger. They had those feature phones, which never gets any link such like this. They said, now what to do? Now, in that case, what do I do? Tell me, I cannot do. But yes, if somebody has smartphones, this is now software is taking care of that also. No email ID can be taken from the mobile also. But if they don't have a smartphone, you can't help it. So then I generally don't have answer to this right now. Okay. Quorum remains 33% like in CIRP. If it is not done, you adjourn it. Same time, same place. Next day. Next day, no quorum shall be required. Even one person coming to you, you are good to go. Do it.
Relief.
Conduct of meeting. You shall be the presiding officer. Commencement of meeting. Take a roll call. Everything remains same. Name, capacity, creditor, etc., etc. You ensure that no other person is attending other than that. Exactly similar to CIR. Voting, you shall take a vote of creditors present in the meeting, listed for voting after discussion. At the conclusion of the meeting, RP shall prepare minutes, circulate it, including name who vote. See, here they say you can take, right? At the conclusion of the meeting, RP shall prepare minutes, including name of the creditors who voted for, against, or abstain from voting on the items put to vote in the meeting. You straight away have an answer here, right? You can take it in the voting also. There is no need of electronic voting. This allows us.
How? By telling them to put in chat box or what? Suppose 50 people are attending.
So this is in front of you. This is what the regulation says. Now it is
Okay, but
RP's, this is
mechanism.
RP's. Yeah, that's what I'm saying. Sir. This is RP. See, now we are talking scenarios. Let's say there is only one person. Why do we need to go for electronic vote?
No
There are
need for.
5 person, we can do it in the meeting itself. We can do by show of hands. We can
Yes.
ask them that then and there they put a message to you.
Yeah.
Then and there they put an email to you sitting in the meeting itself.
Yes.
Another way is you make an Excel sheet with the name, say yes, no, and take a signature in front of it.
So signature is possible only when you are physical. If it is
Sir, we are talking absolutely, sir. So this is we are talking about physical. Let's say they are voting, they are attending by Zoom meeting. How will they do it? So let them send in the meeting in the, you can create, I don't know, I'm just thinking loud. You may create a Google form, you can make a WhatsApp form, let them put it there. Again, we still need to check how IBPI takes it. I'm only trying to give some practical
Yes,
solution.
yeah.
How they will consider it, whether they will think that, why RP is doing out of the, uh, at times doing out of the box thinking is also troublesome. But I mean, as an RP sub, you have to take a call whether you want to do it, you don't want to do it. Your call. Okay. After the meeting, circulate within 48 hours, same as CIRP. You seek a vote on the item listed for voting who were not present in the voting and did not vote at the voting. So see here, they say you take one voting in the COC and people who are not present, you can seek a vote on them from them by electronic means.
Those who are not present or those who did not vote.
See, here they allow you. Those who did not allow, who did not vote, let's say there is a government bank coming, they will never vote it there. They will always take it back to their management and from there they want to vote. So people who did not vote there, they can take it back, they can vote it. 24 hours is minimum time you have to give them. And it says shall, so you don't have an option, you have to do it. At the end of the voting period, RP shall record the decision arrived along with the name of the creditor who voted for, against, abstained, and after considering the voting at the meeting and through the electronic means. So you have option of taking both ways, sir. RP shall circulate a copy of the record made under sub-regulation this to all participants within 24 hours of the voting by proxy is almost similar to how a person can vote. Only thing is they need to tell you, the creditor needs to deliver form C saying that so and so person will do in front of me. So form B, there is only one form. One form is for submission of claim, which is form B. That's all. Normally form B is for operational creditor, right? In CIRP. Here there is only one form for everybody. They will file in form B. Form C is only for the proxy voting. That's all. Repayment plan, here the contents are there. What shall be the content of a repayment plan? Repayment plan shall provide term of the repayment plan, implementation schedule, amount to repay, date to be repaid, whom to be repaid. It also tells you source of the fund from where he will raise money to pay resolution process cost, and obviously this is paid in priority, whatever it is. Minimum budget for the duration of the repayment plan to cover the reasonable expense of the guarantor and members of his immediate family, to the extent they are dependent on him, provided that at least 10% of the realizable income shall be utilized for repayment of debt. In my view, this is not correct, but the law says if he is earning 10,000 rupees, he should give you at least 1,000 rupees. 9,000 he can keep for his immediate expense. Finances required for implementation of the repayment plan also needs to be mentioned. If he has any business, the manner in which it is proposed to be conducted during the repayment plan, and the role of the RP. Whether he wants RP to oversee it, whether he wants RP to open a bank account, receive all the proceedings in that, that is also possible. Manner in which funds held for the purpose of the repayment plan are invested or otherwise dealt with. So he may have a insurance policy which is, which is a endowment, or which gives you money every 3 months. Suppose that policy itself gives you 50 lakh every 6 months. So that money, how that will be utilized, how that will be reinvested, or whether it will be paid accordingly, they can also be mentioned. Functions which are undertaken by the RP, including supervision and implementation, needs to be mentioned. Variations of onerous terms of a, if you remember, in CIRP, a new regulation has come that the monitoring committee, the same RP may or may not continue as the implementation agent. A new RP may also come at the time of implementation in CIRP. But here they are not yet, we haven't touched it yet. We means the regulations doesn't touch it. Maybe going forward, there might be a new RP who can also implement. Variation of onerous terms of a contract. Onerous is troublesome, which he feels that, is too burdening on him. He can let that go, or he can inform that how this needs to be managed. Details of excluded assets and excluded debts, terms and conditions of the discharge. This may provide, I mean, it's a pretty, so when I said there is no format, but what it can include is mentioned in our regulation. So content we have learned. What it may also provide is transfer of or sale of the parts of asset, administration or disposal of any funds, satisfaction or modification of security interest, a reduction in the amount, which has to be there, right? In most of the cases, we will find it. Curing or waiving of any breach of a debt, modification in terms of repayment, part of the income of the guarantor, manner in which funds held for the purpose of repayment to the are not doesn't really matter. Okay, 17A came in between recently in 31st January. It says resolution professional shall place the repayment plan as mentioned in 105 in a meeting for its consideration. Where no repayment plan has been received within such period, RP shall notify the same in the meeting of creditors. So this sounds a bit surprising. I personally don't agree to this. I don't know how many of us agree. When there is no repayment plan, what is the meaning of conducting a meeting and telling them that there is no repayment plan? But our regulation still says that, and it's a recent regulation, 31st of January 2024. Honorable IBBI says that we have to put it in the COC. So, in my view, if you want to be really, really safe, even if there is no repayment plan, please conduct the COC, tell them there is no repayment plan, file the report. That is oversimplification. Purchase of assets by certain person. person shall not purchase or acquire any interest in the property of the guarantor directly or indirectly without permission of the AA. Who shall not purpose? First is RP. RP should not take his car, he should not take his house or any other thing. Or any partner or director of the IPE should not take it. Also, any professional appointed by the RP should also not take it. Any creditor should not take it. Any company where he is a promoter or director should not take it. Or any associate of the guarantor or creditor or RP should take the asset. Now, I don't know where will we sell it, but this is the ineligibility where we should not do it. This looks like we have to put a auction notice and let the general public take it. But yes, if AA allows that nobody else is interested and you can take it, you are free to take that. Filing with AA, RP shall file the repayment plan as approved by the creditors along with the report of 106112 with the AA on or before completion of 120 days. So, any comments on this? We have only 4 months, 120 days. 1 month will go into collation of what? Collation of claims. After that, 14 days notice you have to give, and then you have 2.5 months to do all this process. Every time you can only postpone it by 1 week, the COC. So every week your COCs will happen, and then you have to present the plan in the with the A. So 120 days is the time period available to you. 180 is the total period available for the moratorium. Fine. RP shall provide the copies of the document filed with A to the guarantors, to the creditors. Within 3 days, you have to provide them. Any breach of plan by the guarantor, if in the opinion of the RP, the guarantor has failed in the implementation, RP shall within 3 days, ask them to, address the failure. If there is anything, give them 15 days. It's like, what happens if during the repayment plan, the check bounces? It's like that kind of situation. So suppose he has given a check, even that bounces. Then what? So you give the person, how we give a notice in 138, you give them a chance that within 15 days, you address this failure, provide an explanation for the failure. If the guarantor within the period specified addresses the failure or provides satisfactory explanation, then you file the report that, failure was happened and it has been addressed, not addressed, go ahead. If it is not provided, then you will consider that the implementation has failed. Obviously, then application of discharge, when everything is sorted out, apply within 14 days what we have learned to discharge. Here comes the non-cooperation by guarantor, that 19.2, right? In the event of non-cooperation at any time, the resolution process professional shall prepare a statement to this effect and file the same with the adjudicating authority for appropriate directions. So non-cooperation can be filed under regulation 22. The rest is all forms. You have to give consent. Form B is the claim of proof by creditor. Where they give how the debt has occurred. And Form C is your proxy form. That's all. Three sections are there with this. Rules I don't think are important for you right now because they are normally important for the advocates who are filing in the NCLT. So here they say, so the rule talks about what is the debt, what is the default. Let me show you here. Here they say short title, application, forget the definition, relatives, excluded debt. So excluded assets, just to apprise one and all again, the value unencumbered personal ornament. So if you have given your kada, your Mangal Sutra on Girvi to some Lalaji, These are not unencumbered asset and they cannot be included in the excluded asset. But if there is any unencumbered asset up to 1 lakh rupees, that is excluded. Any unencumbered dwelling unit up to 20 lakhs in urban areas and 10 lakhs in dwelling area, rural areas. Those are excluded. Other than this, nothing is an excluded asset. Fine. Application by guarantor and creditor. You can see the fees of 2000 needs to be paid. Here also fees of 2000 needs to be paid in 95. So normally these are not important for RP, so we can skip it. Confirmation or nomination of professional, again, really not important. Copy of application provide to so and so, so and so. These are just forms. What are the forms? How you ask for the. So there's a demand notice also which you send, right? Prior to filing. There you give 14 days notice to cure the defect. If they make the payment, story is over. If not, you file the application in Form A. So we have covered the act, we have covered regulations, and we have covered the rules. Luckily, whenever the orders are coming, they are detailed orders by the NCLT. They're normally run in 15, 20 pages. And they talks about what all the RP has to do, how he has to, give a notice. Everything is mentioned normally. So luckily the orders are now coming detailed. They put every section in that. How you have to do this, where you have to publish. In one of my order, they said publish in morning daily. They were even so specific that don't publish in the evening newspaper, publish in the morning daily in English and so, which is fine. I guess this everybody must have seen. One of the report, if we have time, so let me show you one of the report how we file as an RP 99 report. Rest of the reports I will not have time to show today. So here you file before NCLT, CP number, main matter, and matter is your name and resolution professional report by RP under section 99. Here you tell the story, how this has happened, what is the debt, how the debt has arisen, your nature of facility, that means cash credit, bank guarantee, overdraft, what was the amount of facility uh, when it was sanctioned. Tell them what is the security available, what are the collaterals available, personal guarantor, when they signed the deed of guarantee, when the CIRP against the CD. So you are like you're giving a report, you're giving a executive summary kind of thing to NCLT to take a decision. And you also give your opinion that as an officer of court, what is your take on it, whether it's barred by limitation, not barred limitation, all that. You also give that as per personal guarantor, what has happened. What if they have given you information, you write it down that it was managed by, you give their side of the story also here. Thereafter, what applicant bank did, you write that. When it is done, the guarantor is liable to pay for so and so. You tell that whether so you give your reasoning, how a court gives you his own their decision. You also tell on what basis your decision is coming to admit or not admit. Post that, I think. So what I also do one thing I have seen, maybe all of you can also use it. Uh, you tell that you are appointed so and so. This is not important. What is important is you give your observation recommendation saying I have checked all the parameters. I recommend acceptance of the application in clear bold letter. You say this should be admitted. They have committed default. Personal guarantor also has committed default. And in light of the above, it is just and equitable that it should be admitted. Apart from that, I advise you to put a compliance chart in it. Compliance chart means there are 10 compliances which you need to do under section 99. And those are section 99 1, 1, 2, 3, 4, like whether RP shall examine a recommendation of approval, yes. 99 2, yes or no. So RP sought clarification for so and so on this email, speed post number, where the date for which an application has been filed, whether so try to give it in an Excel sheet. This is what I have given. All the 10 10 parts, 10 subsection. Let the judges have some comfort in saying that yes, you have adhered to this, you have adhered to this, you have adhered to this. It makes their life easy and makes it little faster.
Very
So
good.
if you
Very
really
good.
want,
Compliance
that's what
chart
I
is
have.
that will be very
This helps
helpful.
them. This helps them in taking a tick mark. You know that
Yes.
fine. RP shall examine application. Yes, RP has examined. After examination, what he did? Yes, RP has recommended. 99.8, what he did? Yes, RP has not recommended fresh start because it has not laid down. RP shall record the reason for recommending. Yes, RP has laid down recommending. So I think it helps the person.
Yeah, it
And
is
it also
excellent.
says RP gives a copy of the report to them. Yes, RP has shared the report with debtor
Yes.
as well as creditor on email and speed. I think it saves
Yeah,
some
yeah.
time.
It's a
So
very
how the
good
report
idea.
is to be filed with the AA?
With AA, sir. So
How? It's
there
like
are
the application.
IA, sir. IA.
IA.
Normally, people are filing as an IA, but if you feel you want to file as an so I have filed directly from my RP ID. You can see this is I filed
But
from my RP ID. Report filed by not an as IA. You can file as an IA if you want to file as a direct. I'm yet to see whether they will shout on me that you why didn't you file as an IA, but can happen. So my advice is file as an IA. So at least because see it will be contested. It's not that your report is only a starting point. It's not the end point. Since it will be contested, you know, largely, uh, I still recommend you file it as an IA and let it go to the adjudicator. Apart from this, last 10 minutes.
Is there any format for this report?
No, sir. No. That's what. So I showed you a sample. There is no format as such, but this is a format which I feel helps in admitting the application. So you have to give the story. It's like executive summary. Executive summary cannot have a format, right? It's your way of working. Most of the advocates have these formats. If they don't have, contact us. We'll help you out with that. Apart from this, I wanted to discuss this last order which came in India Bulls Housing versus Subhash Chandra ji, the G PG. In this case, I don't know how many of you have read this. Anyone other than Anil ji? Anyone is aware of this matter? India Bulls Housing versus Subhash Chandra.
No, sir, no.
No? Okay. So this is a very recent judgment which came in 27/5. It's a very humble, simple case, but why we are discussing it here, you will see. Uh, this was an case, so that they tell you that we were busy, so we could not do it. Okay, now the matter is coming up. Prayer is only simple. Prayer is pass an order under 1982 for replacement of the RP. That's all. And pass any other order. It's a simple order. We have learned in our 3 hours that they have a right to ask for replacement. No problem. Problem comes now when they started, discussing it. And in my view, why an educating authority has to spend 11 pages just to replace one RP? If we are so crunched on time, do we really need such detailed orders? My problem is with that. Their contention was that this RP, namely Rajkumar Sarogi, met the person on 24th 4, during the course of the meeting, he apprised this. This person met in a hotel called Lodhi Hotel, which is a pretty, you know, decent hotel. I mean, high-end hotel, right? It says IBC is a financial beneficial legislation. It is imperative that PG is in a position to repose faith and confidence in the RP. I don't know how many people will agree with this. Reposing faith is one thing. See, if RP is asking for money, is separate. Nobody endorses a criminal intent. But how do you repose faith? On what basis? Your white hair on what? On what kind of car you drive? How do you repose faith? We are all RPs. We are all equally qualified. IPBI does not differentiate. NCLT does not differentiate. Anybody who has an AFA is equally qualified. Whether you are CA, you are CS, you are advocate, you are MBA, everybody is same. How does this comes up? Another thing, he says RP met him in Lodhi Hotel with a lawyer. I mean, meeting with a lawyer, is it such a big crime? They said there was no need for the RP to have the presence of a lawyer at this stage. Held the meeting at the expensive hotel at the expenses incurred, as the expenses incurred in such a meeting ultimately become part of the IRP cost and the
No,
liabilities of the PG.
Ranaji, it is not, let us not put it like this. It is a meeting with a lawyer is a crime. Meeting with a lawyer is required. Right now, you explain what kind of detailed report has to be prepared by the RP in the form of IA. So, uh, you require the services of a skilled person, that is advocate, to help you prepare that IA. Because
So
there are,
they are saying, sir, they are
we are
saying,
dealing with law. We are dealing with
they are
law.
saying, sir, they are saying, Mr. Chaurasia was the lawyer in this case. They
Huh.
said, why do you need a lawyer at the time of meeting? That too in a five-star hotel, because this cost will be included in PG's bundle.
Then,
He will
then
have to
PG,
pay it ultimately.
then PG should not have
Sir,
come
sir,
for
sir,
meeting there.
sir,
PG should
sir,
not.
sir, sir,
PG,
Anilji, let me just finish it because
uh,
many people are not aware of this order, and then we will keep that 2-3 minutes for our discussion. Fine. So RP met with a lawyer in a five-star hotel. That's all. They said that he should not have come to a good place. You should have met only in a cheap place. It looks like, that is their defense they are saying. Now they are also using the words which you discussed. ये matter तो bankruptcy में जाएगा. So what else an RP will tell that if you do not give a repayment plan, obviously it will go to bankruptcy. If the RP is saying that, can it be a ground for changing the RP? But let's say we'll move forward. They say ये matter तो bankruptcy में जाएगा is a threat. Why is giving threat? Next. He did not take any such initiative to seek permission for conducting the negotiation. He's saying why an RP is doing negotiations. What is his interest? Why? So if he wants to do any negotiations between debtor and the creditor, he needs tribunal's permission. So these kind of averments are coming. Now what our honorable NCLT says, okay. So lack of transparency, all that story is given. I still recommend if anybody is interested in this, may go through this order. India Bulls Housing Finance versus Dr. Subhash Chandra. And now Dr. Subhash Chandra is a big man, right? Why will you meet him in a Madras cafe? You will obviously meet him in a decent place, right? But that is coming back on RP. It is haunting back. Uh,
Subhash Chandra
okay.
may not like to meet in a Madras cafe, you know.
Exactly my point, sir. So why
And,
will you meet
and
somebody in a...
then Dr. Subhash Chandra should have invited RP to his office, his residence.
No, then
He
if
should not
RP
have.
is
He should
going
not
to...
have gone. He should have declined.
Mm, sir,
He
but then RP will also decline. Why will an RP go to his house to
no
take
no
his
no.
approval?
Okay, independent place, office, RP's office. RP's
Sir,
office.
hotel is, sir, no big person comes to RP office, sir. I have not seen. They always ask you to come to a hotel.
Then
So we know that, right? That we know the practically what happened.
yes. So then
Now,
that also should come on the record that they themselves call big person and IP they consider as a puppet. Why? Who are the big? Who is big and small? Where is the definition of big person and small person in IBC and law? Everybody is equal, even if you have 1,000 crores or 2,000 crores.
agreed, sir. Now it says RP has exhibited discreteness and vagueness, implying lack of bona fide at his behest. Uh, it says personal role of a RP in the proceedings is that of a negotiator, collaborator, facilitator. On one side, he says this, and on another side, they say who gives him authority to make the negotiations. But he says he is negotiator only for my help, not for the banker's help or the creditor's help. See, they putting explanation is fine. My problem comes with where the uh, educating authority talks here. So they are putting everything, whatever claim they have made. We heard the counsel for the parties. Allegations made in this matter were obviously denied by the RP. Mr. Chaurasia, who represented him, was there. Nevertheless, they have categorically admitted that on 24th, they met the PG in Lodi Hotel. Mr. Chaurasia effectively participated. It nowhere appears that the RP could agree with him, any lawyer, to meet PG while seeking to discharge. I don't know what it means. They say nowhere it appears that RP could carry with him any lawyer to meet the PG while seeking to discharge his function in terms of Section 805, the stage when PG has to prepare his repayment. They say after this lawyer role will start, that time it's better. Don't take initially. Somehow this order is giving that impression to the fraternity. We could also pursue the IBBI regulation. Even these regulations do not indicate anywhere that RP appointed by this tribunal in terms of Section 97 is entitled to take the assistance of a lawyer while discharging his function at that stage. When the PG was yet to prepare his repayment plan, we are unable to appreciate why and how the RP felt the need to conduct the meeting in an expensive hotel when the responsibility given to him was to conduct process for insolvency resolution. I personally feel they could have refrained from making such statements, but they have made this
So
statement.
here they are saying, Ranaji, here they are saying that RP cannot take the help of lawyer at that stage. They are saying.
So this is the order. This is a public document.
Ah.
I'm not making
that
it
is-
up. It's
No, here it is very clearly they are saying. So if that is the precedence, then it will be difficult for RP to function.
let's go further, sir. It's only 8th page. We are on 11th page. So luckily, so this is the view they gave. Luckily, they did not pass an order on this. This is the view. Now they say, provided that where they have admitted under Section 10, it may, on the request of RP, issue instruction for the purpose of conducting negotiation between the debtor. Apparently, no such request was made by RP. I don't understand. To conduct negotiation, why do you need a permission? But here also they say when A admits an application, it may on the request of the RP issue instructions for the purpose of conducting negotiation. No such request was made by the RP when we heard the matter in 95. Now at 95, where does RP makes a recommendation to conduct negotiation? When? Never. We have never, I have never ever seen any RP saying, let me do the negotiations. Why will they do that? Again, while discharging function in Section 105, RP is role of the RP is only to extend the service as a consultant to the PG. When in terms of the provision 105, read with regulation 17, role assigned to RP himself is that of a consultant, and repayment plan has to be prepared only by the debtor. It is difficult to appreciate that the RP, whose presence itself is recognized and acknowledged as that of a consultant, can have the service of another lawyer. Okay, so I'm trying not to make a mockery or anything, humble due respects, but I believe these orders should be challenged by somebody. At least this person needs to challenge. Okay, regulation says the repayment plan has to be prepared by the debtor and it is for him to consult the RP. Reading of 105 further makes it clear it is only in terms of the repayment plan that the RP may be required to or authorized to carry the debtor's business, blah, 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 doesn't matter. So when there was no such authorization in favor of RP, we are unable to appreciate and comprehend that how the learned counsel for the RP could rely on regulation 18. Such arguments could be appreciated only if personal guarantor would have made authorization in favor of RP. So only if PG allows RP to appoint a lawyer, you are allowed. So at this stage, Mr. Chaurasia interjected, submitted that when 18 provides that that the professional appointed by the RP for the regulation shall not purchase and acquire any interest, blah, blah, blah. So obviously he was entitled to carry with him a lawyer while meeting. So, okay, Lodi Hotel, nobody is agreeing. Okay, they also said, he also made reference to the regulation 3.1 of the aforesaid regulation to espouse that when resolution process cost include the fee payable to the professional engaged, the RP was justified in taking him to the Lodi Hotel while meeting the personal guarantee. And now, luckily, they said, okay, forget it. We are not saying anything. It would be out of the context to note that during the hearing, the PG could suggest couple of names. The plea was opposed by Dhawan, blah, blah. They say, we appoint Mr. So-and-so. It is made clear that nothing observed herein should be held against the lawyer or so-and-so. We have ordered replacement only because the procedure given in this allows it. My only contention as today,
There was a
this
need
would
to
have
say
been,
all
this
those
is
things.
enough. Sir, this
Ah.
is enough.
Ah.
This one page is enough. Who is fighting? Nobody. They just say, okay, they want replacement, put a replacement. If you are giving all these views, it Raja ka nivedan hi आज्ञा hai, right? So if my lords are putting
There is a
that
need
kind
to,
of view,
there is a need to write all these gossips
so
in
now
order.
they're saying do not
Ah.
take it against them. It should
Ah.
not be held against them, which is fine. But you have already made the damage.
Ah.
That
So,
IBBI will be after his life.
yes,
Trust me. They will open a Pandora.
not
They'll say,
only
how can you do
IBPI,
this?
not only IBPI, there are many things stated here. He will be, RP will not be able to hire a lawyer. RP will not be very conveniently be beating PG at any place,
Don't go to 5 stars, sir. First.
So 5-star or any star, So where should he meet? How should he meet? With whom he should meet? If you go to a physician, and then if you have a special health problem, you go to the consultant, special doctor.
Anilji, we have come to the end of the session today. If anyone has to say something, we are fine. Otherwise, ICSI, please come into picture.
And I think you have done a wonderful job by refreshing all the provisions, and we have learned a
Thank you,
lot.
sir. Thank you, sir.
Yeah, it will help us.
Yes,
Compliance
Ranaji,
chart
it was
was
a
very good.
great session.
Yeah.
It was a great session. You explained well, and it was interactive
I
also.
tried.
Great.
I tried.
Thank you, sir.
Thank
It is a wonderful
Hello,
session.
hello. Sir, a very wonderful session. What that other two speakers commented about the class, I also vouchsafe. Kindly put it your cell number and the PPT in the chat box, sir, please.
Okay, I'll do.
Thank you so much, sir.
We have another session in the evening. Uh, uh, I think our ICSI team may say that. Uh, I think 2 to 5, right? 2
Yes,
to
right.
5 is our. This is my number I've shared in the chat box. If anyone needs any help, I'm more than happy. I'm doing PG, BT cases in Hyderabad, Delhi, all over. And we'll be happy to share even these formats if anybody needs application, etc. Please feel free to get in touch.
So
And
this PPT as well as this India Bulls case also, you please put it in the chat box, sir.
compliance
I
chart is an
don't
excellent idea.
come. Okay. Uh,
It is just like Form H when we submit resolution plan.
yes, yes, yes. It's like format, sir. Absolutely right. So let
We end
me.
this session, and on behalf of every participant, I would like to thank Sir for taking this session and making it knowledgeable and interactive. Thank you so much, sir.
Thank you, sir. It's a good day.
மாரியமுத்து தம்பி நந்தகுமார். மாரியமுத்து அவனுக்கு சுப்பிரமணிக்கு ஃபோன் பண்ணீங்களாப்பா? வேலை முடிஞ்சிருச்சா அப்ப நான் நேத்தியே?
Hello, good afternoon, everyone. Am I audible?
Yes, you are audible.
Okay. So now the session will be taken by Ms. Preeti Garg as faculty on the topic Decoding the Pre-Packaged Insolvency. Ma'am is a qualified company secretary and advocate. She has a rich experience of 12 years as practicing company secretary and 8 years as an advocate. She is an insolvency professional and a registered valuer. She is also a visiting faculty of ICSI NIRC, ICSI IIP, and ICSI RVO. She has also contributed as author for the books of ICSI academics on a regular basis. Ma'am, you may now start the session. Over to you.
Thank you. Thank you very much.
Thank you.
So, hopefully, thanks for such a wonderful introduction of mine. So, I am an IP Preeti Garg. I'm going to start with the topic pre-pack insolvency resolution process. Before that, I would request all of you, those who are in a position to switch on your videos, please switch on your videos. And let's have it like an interactive session. All of you, please, because PPIRP is altogether new for us. We are dealing with CIRP since 2016. CIRP is in the pic. All the sections are there, but regulations are notified only with respect to CIRP. So what's the need of PPIRP? That's the discussion first. Anyone of you who has dealt with the PPIRP in your assignments? Or has come across with any query like with respect to PPIRP? Any one of you, any query or anything? PPIRP, very few cases are there till now, because it was initiated in 2021. It was introduced in IPC. So hopefully, I don't think anybody would have come across with the experience or hand-on PPIRP cases, but we expect sooner a rise in the PPIRP cases also. Let's start with it. Before giving the background of it, before giving anything, I would like to discuss about first what are the provisions in the code being introduced with respect to PPIRP. I'm sharing the screen. Anything, if during any time I am not audible or my PPT is not visible, then please let me know about the same. Is my PPT visible to you? Unmute yourself and speak,
Yes,
please.
yes.
If it is visible, fine. So we are going to decode the provisions of the IBC with respect to pre-packaged insolvency. Right?
Yes.
Yeah. So that's chapter 30 was introduced in it with the name chapter 30. If we know about the structure of our part 2 for the IBC, it was having 7 chapters. All were dealing with CIRP, liquidation, fast track CIRP, voluntary liquidation. So whatever the insolvency resolution process relates to the corporate sector, the same were being dealt in those chapters. Then there was a need to introduce a special resolution for insolvency of MSMEs. That's why a special chapter 30. So whatever is in first, second, third means they were original there. So anything that is being introduced in the code, in the name with the third A, PP, 54P, 54A means they were being introduced later on in the code. Chapter 30, pre-packaged insolvency resolution process, the governing framework for IBC 2016 was amended by the Insolvency and Bankruptcy Amendment Ordinance 2021. We all know this was being introduced in the code by way of ordinance, and most of the amendments are made in the code by way of ordinance. There is something in the chat box. Okay. Then whenever the code comes, sections are not sufficient to implement them in practical. So there are the rules as well as the regulations that were being notified simultaneously. The code was notified on this chapter was notified on 4th April 2021, and it was really appreciable that within 5 days they come out with the rules and regulations. That is with effect from 9th April, they came out with the rules and regulations relating to the PPIRP. Before starting the discussion on the PPIRP, we should know about the MSME Development Act 2006 because it defines what a MSME is. So unless and until a corporate debtor is MSME, PPIRP is not for it. So first of all, let's see what is there in the MSME definition. how this journey started. We all know there was the time of COVID, and the COVID was the time when everything was down, industries were down, MSMEs were especially in danger. So IBC was altogether suspended almost for a year. During the time on 25th March 2020, IBC was suspended, and then 24th March 2020, they raised the limit of default from 1 lakh to 1 crore. So that they are not getting the applications for very small defaults which are expected during the tenure of the COVID. A subcommittee of ILC was formed on 24 June 2020 to give a report on pre-packaged insolvency resolution process, which suggested pre-pack insolvency resolution process for those corporate debtors which are falling within a limit of 1 lakh to 1 crore and for MSMEs also. But later on, it was accepted only for MSMEs. The public comments were invited in January 2021, and then the ordinance was brought, we all know, with effect from 4th April 2021. After the ordinance, when it became a part of the code, it was introduced in the code as part, then ILC committee report was there on PPIRP in July 2021. And then it became the part of the code with effect from 11th August 2021, Amendment Act 2021. But the applicability was with retrospective effect, that is 4th April 2021. So this was an introduction, how the committee formed and how this PPIRP became a part of our IBC. When we have a look at the subcommittee of ILC report, it says that Government of India is taking several measures to ameliorate the pains which are emanating from COVID-19. So it increased the threshold of default from 1 lakh to 1 crore. So as to prevent MSMEs from being pushed into insolvency proceedings. Moreover, apart from it, there was one more thing. For CIRP, you need resolution applicants. Who are the resolution applicants? They are another corporate sectors. But when everything is falling in the economy, how will you find resolution applicant? Because resolution applicants were not available. That's why IBC was suspended. But during this IBC suspended, what will happen with the default? That was the core concern of the ILC report. It takes into account that we can go ahead with the resolving the stress situation arising out of the financial crisis. Either one can go for the CIRP under the code, or they can opt for the scheme of compromise or arrangements under the Companies Act by the voluntary compromising with the terms of the loans. Two of the out of the court options were RBI's prudential framework for resolution of the stressed assets, and we know there were many cases in Surfasi, especially during the time when IBC was suspended. Informal understanding between a debtor and creditor with or without the help of a mediator. That would be the course of actions. But what is a pre-package? Pre-pack means this was an innovative corporate rescue method which incorporates the virtue of both informal, out of court, and formal judicial insolvency proceedings. It seems to be preferred hybrid framework, because when you will go through the structure of pre-packaged insolvency resolution process, you will find that before a part of it is still in the hands of the management who are running the corporate debtor. What was the purpose of CIRP? SICA got failed. Why? Because those who were responsible for the financial crisis of the company, they were still in the control of the company. They were still in the management of the company. That's why in the CIRP and in the management is vested in independent professional, that is insolvency professional. But MSME is a sector where it is generally family-oriented business. Small amount of investments are there. So very less persons will be interested in it. So they say, let's have a process like something. For a part of it, it is still managed by those who are still running the MSME. But it is under the supervision of an independent professional, that is IP. And there will be least interference of the judicial authorities. Because of all this least judicial interference, it is considered to be fast, cost efficient, effective in resolution of stress much before the value deteriorates. Because one of the objectives of IBC is to maximize the value of the assets. To keep that in mind, it is said that it is fast and cost efficient, and it is again a time-bound process. PPIRP is again a time-bound process with the least business disruptions and without attracting the stigma which is attached with the formal insolvency process. If we look outside India, it is very much prevalent, but in India, it came from 2021. It is an informal understanding which is engaging the stakeholders. They are coming out with the compromise between them and then with the resolution. Am I audible? Am I audible?
Yes, madam.
Yes, ma'am.
Okay. Yes, madam. Yes, madam.
Yeah. Thank you. So let's go through the structure. PPIRP Amendment Ordinance 2021. 19 sections were added in our code. That is section 11, capital A, chapter 3rd dealing with section 54, capital A to 54, capital P, section 67, capital A, and section 77, capital A. These were the sections which were being added along with the rules and regulations, and the provisions are there. Provisions of CIRP were made applicable to PPIRP with modifications. And what are the modifications? We are going to check it. We are going to cover this ILC report salient features of MSMEs after we cover section 54, capital A to 54, because then the chart will be clear to us. Whatever is stated, we are able to relate where it is. If I go through this chart, this is the sections numbering that they have introduced starting from. They have started the sections who are eligible for PPIRP. And then there, before PPIRP begins, is there any duty of insolvency professional? Is there any role of insolvency professional? Because in CIRP, IP role begins when CIRP commences. But in PPIRP, the role of IRP begins even before PPIRP commencement. Then there is an application to initiate PPIRP. Time limit is always there for completion of any process in IPC. Moratorium, public announcement is there. RP has a duty before PPIRP also, and even after PPIRP also commences. Before PPIRP, he is simply an insolvency professional, and when he is appointed, he is known as resolution professional. Then they are giving how the claims are going to be submitted, preliminary information memorandum, management of the affairs of the CD, then committee of creditors, and then how the resolution plan will be approved. Can we appeal? Or what will be the consequence if the PPIRP terminates? If PPI terminates, will it result in commencement of CIRP or liquidation? And what are the provisions of our CIRP procedure, chapter 2, which will be applicable to it? So let's start it. As first of all, a CD, which is an MSME under subsection 7 of the section 7 of our MSME Development Act, is eligible to apply for initiation of PPIRP. To begin with, I will say, I have said that it shall be a MSME, and according to MSME Development Act. Similarly, section 240A was modified, which says that provisions of section 29A, C and H shall not apply where MSME is a resolution applicant for CIRP or PPIRP. So what is this MSME? We have got this definition from the example of section 240 capital A, which is saying that at the same time these provisions were thought to be brought in the code, at the same time the MSME classification was also revised, and it was based on investment as well as annual turnover. And this was applicable for MSMEs involved whether in the manufacturing as well as in the service sector. The same criteria was there. So if the investment is up to 1 crore and turnover is up to 5 crore, they were known as micro. Investment up to 10 times, investment up to 10 crores or turnover up to 50 crores, small scale, and investment up to 50 and turnover up to 250 crore, then medium enterprise. So first of all, a CD shall fall within this any of this criteria to start with PPIRP. Once he is starting with this criteria, once it is started with this criteria, then we look for what is the default limit, whether any particular default is required. Now, what happened at that time? Section 11, capital A was basically introduced, which state that PPIRP's application is initiated only by a corporate debtor, while CIRP application, will all know, can be initiated by the financial creditor or operational creditors also. So what happens if CD goes with the PPIRP applications and any financial creditor comes with the CIRP application? Which will be decided first? PPI application is pending, and in between a financial creditor initiates CIRP application. So it was stated that adjudicating authority will decide first the PPIRP. This will be decided first. Now, another situation is any creditor has come out with the CIRP application. This situation has come out in practicality in one particular case also, that PPIRP was in pipeline because PPIRP is not one day. The application cannot be filed within 1 day of thinking that we are going for PPIRP. It takes time, around 2 to 3 months before being prepared to file application for PPIRP. So during that time, when the creditor knows that the company is in a phase of filing PPIRP application, he goes and file PPI, initiate CIRP. Within 14 days of initiating CIRP, still the CIRP application is pending. PPIRP application is filed by the corporate debtor. Now, which application the adjudicating authority will decide? If it is filed within 14 days of initiating CIRP, but when the CIRP application is pending, then adjudicating authority will decide PPIRP first. However, if application for PPIRP is filed after expiry of 14 days from the when the application to initiate CIRP was filed, and CIRP application is also pending, so adjudicating authority will decide CIRP first, and then if CIRP phase it rejects, then it will go to PPIRP. Otherwise, the CD will be admitted to CIRP. If you want to look for the cases like this, how the section 11 is coming, it is specifically saying if an application filed under 54C is pending, then adjudicating authority will decide the order admitting or rejecting the 54C application before deciding anything with respect to section 7, 9 or 10 application. If the same is pending and 54C application is filed within 14 days, because application to initiate PPIRP is filed under section 54C. So it is stated that application under section 54C is filed within 14 days of CIRP applications, then first dispose of 54C application. If after 14 days, then first CIRP application and then 54C application if required. The provision of this section are not going to apply whenever this ordinance was brought into pick, that is 4th April 2021. If on that date an application under section 7, 9 or 10 is pending before the NCLT, then no provision of this particular section will be applicable. Whatever with the application of CIRP, it will be decided first. In case that is rejected, only then PPIRP application again filed will be considered, otherwise no. I hope this is clear. Section 11A about the chronology in which the NCLT is going to decide which application first.
Yes, ma'am.
If I look for this process is divided into parts. First is a default by MSME, and it was being notified by the government that the default by the MSME under this shall be at least 10 lakh. This default again, like this think there was a section. This default of 10 lakh was being notified by the central government, and this can be raised up to 1 crore. This can be raised up to 1 crore by the central government, just like the government raised the default limit of CIRP from 1 lakh to 1 crore. It can be raised from 10 lakh to 1 crore also. Then there start a pre-initiation phase in which there will be preparation by the corporate MSME for filing the application for PPIRP. That's why we called it as a pre-initiation phase, which is largely informal because corporate debtor is dealing on its own with it to resolve the stress. Whenever an application is admitted, whenever an application is filed, there will be annexures, documents, and forms that are to be attached with our applications. And then PPI's commencement date when it is accepted. What happens after the pre-pack insolvency commencement date is known as post-initiation phase, in which there will be a plan submitted by the promoters also. There may be a plan invited from the outsiders also. And then finally, a resolution plan will be approved. And whether a resolution plan is approved or not, PPIRP will be closed. And there are many situations in which PPIRP can be closed that we are going to discuss. So this is just an outline how that is going in breaks. First, in pre-initiation phase, we are going to understand it through chart and then through words, relating it with the words. There will be a meeting of the financial creditors. Obviously, these financial creditors will be all unrelated parties. Unrelated financial creditors, at least 10% in value, will give a proposal to appoint a resolution professional. First of all, see, 10% in value or by unrelated financial creditor will make a proposal to appoint an insolvency professional. And this proposal for appointing resolution professional will be approved by the financial creditor with 66% voting. Now, with this 66% voting, so first phase is appointment of insolvency professional by the creditors themselves. What was happening in CIRP? Insolvency professional was appointed by the adjudicating authority. The same is happening in this, but before that, the financial creditor themselves appoint it. So there is no concept of interim resolution professional. He is themselves approving that this person can be appointed as a resolution professional. Whenever this is fixed, then there will be a meeting of the board of directors, where by majority of the directors or the partners, they will give a declaration in form P6. See, whatever are these forms, they are being stated in the regulations. So form P6 mentioned in the regulation provides the format in which declaration are to be provided. And what is it that application, what they will say first, that we are going to make an application to initiate PPIRP within 40 days, within 50 days, within 60 days of this declaration date. And this they can go ahead for the maximum 90 days, not before that. But whatever their days they are stating here, 40 days, 50 days, 60, if they fail to file the application within that stated period, this PPIRP terminates. So whenever they are giving it, they are already planning whatever the work is to be pending, whatever the documents are to be prepared, they are prepared in hand. And this is the responsibility of the corporate debtor, not the insolvency professional. So that's why this is known as informal process. Second declaration, they are saying this PPIRP is not initiated to defraud any person. Defraud any person means not only defraud, it is not meant to defraud any creditor, not meant to defraud any shareholder, not meant to defraud any other authority. Nothing is like that. They are not defrauding any person. And name of the insolvency professional who is proposed here and approved as RP by the financial creditor. That will be given in their declaration that this is the person who is proposed as an insolvency professional by the financial creditors and approved as a resolution professional. Now, after that, see, if you want to relate it, you can relate it how the corporate debtor is making an application to initiate CIRP. Whenever a corporate debtor is making an application, it cannot make an application without the authority of the shareholders, if it is a company. So it's a meeting, a general meeting will be convened for the special resolution. In case of LLP, by the 3/4 majority, the proposal will be approved. That okay, go ahead for the PPIRP. Then again, financial creditors meeting will be convened. See, this is taking twice. Now, this was only for the appointment of insolvency professional. This meeting is to go and approve that, okay, go ahead and file the application for PPIRP. That's the approval they are taking from the financial creditor. And whenever this meeting of financial creditors is convened, in this meeting, they will give this form P6 that we as a directors have made this declaration. This special resolution which is passed by the members of the company and a base resolution plan. Just giving you a hint, base resolution plan is a plan which is prepared by the promoters, existing promoters, that how they want to resolve the insolvency of MSME. What is in their mind, what haircut they want from the creditors, what else is required. And then as soon as this application has to be filed according to the rules. Whenever we file an application with the NCLT or the authorities, we go by the rules. So this form P1 is given in the rules, and it is with a fee of 15,000. Application is filed to the adjudicating authority. This is the whole phase, and one question comes in the mind: if this is going like this, what is the difference between this CIRP or PPIRP? Why this PPIRP and not CIRP? First of, because corporate debtor can go for CIRP also. Then why it will go for PPIRP? First of all, the default limit is less. Second thing is, it is within the control of the management. They are proposing a resolution plan. And as soon as this application will be admitted, moratorium will be in effect, which will there be in CIRP also. But if they are simply going by the scheme of compromise or arrangement, moratorium facility will not be there. An independent professional is there to supervise all this. Whenever this application is filed, this insolvency professional has a duty to prepare a report with respect to this MSME, whether this is eligible to submit this plan or not. So he is supervising all this. This application is going here. NCLT can rely on the report of the insolvency professional and can either accept or admit or reject the application. This is what the role, how crucial the role of insolvency professional here is, that NCLT is going ahead considering the report of the IP before deciding for admitting or rejecting it. Now this is what section 54A is saying again, that a corporate debtor shall be classified as MSME. So these are the conditions. So wherever you will see now, what is to be seen, section 54A conditions are fulfilled or not. So what are the conditions of section 54A? MSME, default. What is the default? This is the default matters. You know, section 4 says minimum default is 1 lakh, which can be raised to 1 crore by the central government. And in this case, they have notified the same for the PPIRP also. And in the notification, they mentioned the default for the MSME shall be threshold default to initiate PPIRP is 10 lakh. Apart from this, they are giving a cooling off period, just like section 11 was there in CIRP, saying that these person cannot go for CIRP. Similar way, there are some persons who are not eligible to make this PPIRP application. When MSME cannot make this PPIRP application, it is known as cooling off period also. If on the date it is making an application for PPIRP and you look back for the 3 years, in the back 3 years, it has either undergone PPIRP or completed CIRP. Then it cannot make an application for PPIRP, because at least 3 years are required to give effect to what was the resolution plan being approved in that PPIRP or CIRP. Similar way, if MSME is undergoing CIRP, simultaneously it cannot make application for PPIRP. Two processes can't go simultaneously. Similarly, one more, if it is undergoing liquidation, then it cannot be that some financial creditor or operational creditor can go and file an application to initiate PPIRP. No. Corporate debtor is when making this application, it is submitting a base resolution plan. And we all know that for submitting the resolution plan, one should be eligible under section 29 capital A. That's why this is said that MSME at the time of making application is giving a base resolution plan. So it shall be eligible to submit a resolution plan under section 29 capital A. But my section 240 capital A says that two clauses of section 29 capital A are not applicable. One is of the NPA account, other is of the guarantee. Apart from that, if there is any other disqualification, CD cannot make an application. Again, now the financial creditors, first meeting of a financial creditor is there, which is of not related parties, where at least 10% will make a proposal to appoint an insolvency professional as a resolution professional. And this proposal, see, there is a difference. First is the proposal, for which threshold is 10%, and then approval of this proposal shall be by 66% in. That is where the difference stands. Now there is a provision also, if there is no financial creditor in the MSME, or all the financial creditors are related parties, or all but one are related parties, then who will constitute this financial creditors meeting, or who will constitute the meeting of the creditors? This is also given, just like in CIRP, the hands goes in the favor of operational creditors. Then how much we will see this. Then again, the declaration by the majority of directors in form P6. And one thing I would like to discuss these forms also, because when I am in a practice, I have to go by these forms. And what I have to do, if I have hand on these forms, I know what the entire PPRP is. My work is documenting the work according to these forms. Form P6 is by the directors, and when they are going to make an application, not defrauding and all, then the special resolution, and then finally the approval by the financial creditors meeting. One thing that was left out is, whenever this second financial creditor meeting is conducted, at the second time for final approval, some documents are to be provided. And what are the documents? They are declaration, because what the declaration will tell them, this will tell them that when the PPI application will be made, and this is not to defraud. Now the onus of not defrauding is on the directors. And whatever the resolution passed by the members, so it is an authorized way, members have also approved the same. And this base resolution plan. This base resolution plan is utmost important, because PPRP aims that existing promoters of MSMEs are feeling that they are not able to resolve this insolvency stress. So let's have some plan under the supervision of an independent professional with the minimum interference of the judiciary authorities, so that, and they want to take advantage of moratorium also during the time this insolvency is going to be resolved. That's why they come to PPIR. Now, when this approval by the financial creditors, we always have to look for the regulations also. How this is going to be there? Corporate applicant can convene the meeting of financial. This is before the PPIRP phase. Corporate debtor can convene the meeting of the financial creditor, but it has to give at least 5 days notice. And this 5 days notice, this is not the responsibility of we as an insolvency profession, but to the extent I believe that whenever any MSME is planning to come into PPIRP, or whenever any comes for the consultancy, they want all the consultancy and guidance from a professional in this regard, that how they shall proceed. And there comes the role of insolvency professional as a consultant also. That they have to convene a meeting of their unrelated financial creditors, giving a 5 days notice. Can this notice be a short-term notice also? Because they are in a hurry to go ahead with the process. You will say, if all the unrelated financial creditors agree to it, 100% approval for a short-term notice, then you can go for a short-term notice also. I think this is visible, or shall I zoom it?
Yeah, okay. Possible to read, madam. No issue.
Okay, fine. Thank you. So 5 days notice is given to the unrelated financial creditors. Remember, corporate applicant is conducting 2 meetings of the financial creditors. One is for the appointment of IP, and last is one is for the approval of the application for PPIRP. So this provision is applicable for both. In the first, unrelated financial creditor with 10% in value propose the name of IP, and when they are approving what will be the terms of the appointment. So my appointment here belongs to the first meeting of creditors, and my appointment terms will be there in the form P3. What is the most important concern for who will pay the fee? Who will pay the fee? Now, the fee is for what process the fee is payable. See, the role of the insolvency professional starts from here, and he has to submit a report to the adjudicating authority along with the application of form P1. His report also goes here. So his role starts from here in preparing the report, in which finally he recommends whether the MSME is fulfilling the requirement of section 54A and whether the base resolution plan is conforming or to the requirements of section 30 or not. Those things are there. So who will pay fee for this particular time? Can you tell me who will pay fee for this particular time period? Or who shall pay fee for this pre-initiation phase? Any idea? Financial creditors committee will pay it, or the corporate debtor will pay it, or we are going to do it without any fee payment?
Corporate debtor will pay.
Yes, it's the time the corporate debtor will pay. Now, once the application is submitted, even then who will pay the expenses to be incurred by him? Because the management will not invest in him. He will do other work during that particular time period when the process is going on. Then fee payable and expenses to be incurred will be mentioned in form, and this will be paid by the creditors. And the fee, if the management vests in the RP, then what will be the fee? These are the three things which will be declared at the time the application is made to initiate PPIR. So we are clear cut what is going to be, who is responsible for making the fee, payment of the fee, and what will be the fee and expenses payable. Similarly, if there is no financial rate or where all the related parties, then it shall be convened corporate applicant. This is pre-initiation phase. Calling the meeting is the responsibility of the corporate applicant, that is MSME. It shall convene a meeting of operational creditors who are not related parties of the series. And then all the provisions are same, which will be applicable to the meeting of the OCs also. We all know in CIRP also there is a provision for constituting meeting of OCs in case there are no all the financial creditors are related parties. Similar way is in the PPIRP, that COC shall consist of all the financial creditors, but financial creditors who are related party can neither participate, vote, or represent in the meeting. They are just, what I understand, they are just like interested directors in the board of directors meeting. Similar is they are the related financial creditors are treated in the committee of creditors. And in case there is no financial creditors, all but one are related parties, then it shall consist of 10 OCs largest by values. 10 OCs largest by value, and if there are 9 operational creditors, 8 operational creditors, so whatever is the number, it will constitute the part of committee of creditors. One representative of workmen, which is not included in this 10 OCs, because workmen are also operational creditors, but there is a separate representative required for them. And similar is a representative required from the employees, which will not be included in these 10 operational creditors. Right? One thing is this. Now, fine, your committee of creditors has been defined, who is going to constitute it. Form P2 is being examined. What is Form P2? Form P2 is the notice of the meeting. Format in which corporate applicant shall give notice of the meeting of the creditors to the creditors. In that notice, what is required to be discussed in the meeting, that is the contents, time, and venue of the meeting. Apart from these things, list of creditors along with the amount due will be given to them. List of creditors along with the amount due will be sent in the notice of the creditors meeting. So who is responsible for this list of creditors? It is the corporate applicant. In the CIRP, resolution professional has to collate the claims and then constitute, verify the claims, and then constitute the committee. Here, RP is not burdened with this role. It is the duty of the corporate applicant from the day it starts to initiate, conduct the meeting of the financial creditor. It has to give in that meeting notice a list of creditors with the amount due. So simultaneously, when it will go to those creditors, they are able to verify the claims which are being mentioned in the notice. And in case of any dispute, they can resolve it with the corporate applicant itself. That are this is our amount, you have stated wrong or something like that. This will be stated in itself also. From this is the source of information for the insolvency professional. He will pick up the name of the creditors with the amount due from Form P. Right? Because we all know there, apart from the committee of creditors, there always exists a class of creditors. There may be a class of creditors for them also, like generally it's in case of home buyers also. There is a class of creditors committee to be constituted. So he will first of all, this is the appointment of the getting the selection of the authorized representative is the responsibility of the resolution professional. So it is said that the resolution professional shall ascertain the class of creditors which are not relatives of the applicant, corporate applicant, related parties, nor they are relatives of the resolution professional. Then for representative of the creditors similar to CIRP, he will identify 3 IPs who are having their address as registered where highest number of creditors in the class as per their records are having their residence. And if not such state is available, then nearest state will be there. Then he shall be appointed, eligible to be appointed under regulation 7 means he shall not be a related party of the corporate debtor. The authorized representative shall not be a relative of the resolution professional. He shall not be auditor of the company in the last 5 years. These things are there. And then he shall be willing to act as authorized representative means whenever their name is proposed, it shall be with their consent to act as an authorized representative. And this consent is given in the form P5. So for me, this form P5 is itself relevant. Then you will see, he will seek the choice of the creditors who has consented, and this choice has to be given within 3 days. They will select the insolvency professional, and then this name of the insolvency professional selected will go along with the application, along with this consent in form P5 to the corporate applicant, and corporate applicant will then file the details of the authorized representative along with his consent when it will file the application to initiate PPIR. Fine. These are the things for the authorized representative. The form P5 is relevant, but ultimately responsibility to file, consent, and who will be the authorized representative is of the corporate applicant. Now, when RP has to play this role, he will play this role during the PPIRP phase. When he will take the P2 form P2 in the first meeting when he is being appointed there in the committee, he will look for who are the members of the committee of creditors, what is the amount due to them, and then he will find whether there is any class of creditors or not. If there is a class of creditors, he will look for the appointment of the authorized representative, recommending the 3 names and then getting that selected. Once it is selected, the name will be forwarded to the applicant, and applicant will file this form P5 with consent along with form 1 and fee of 15,000 to the NCLT. So this is what this role is played by our IRP and CIRP after admission, but role in PPIRP has to be played by the resolution professional even before PPIRP commences. So next is duties of IP before initiation of PPIRP. What are the duties of IP? The IP proposed to be appointed as RP shall have the duties from the date of his approval of being appointed. From the date of the first meeting, his duties start. He has to prepare a report in the form that is P8 specified. And what is it? He will say, okay, corporate debtor is meeting the requirement of section 54A, and base resolution plan is conforming to the requirement, means it is conforming to the requirement that is applicable to our resolution plan in CIRP also. It is conforming to the requirements which are mentioned in the section 54A. It is filing such reports and documents with the board as may be specified, and other duties, they are to be specified in the regulations, but no such separate duties are still there. Whatever are the duties, apart from this, they are mentioned in the regulations also. Till when this pre-initiation phase duties are applicable to the insolvency professional? When it will come to cease? These duties are relevant only for filing the application for PPIRP. Say corporate debtor fails to file it within the days specified in the declaration. Then they cannot go ahead for filing PPIRP. Or NCLT terminates or admit the PPIRP application. Because once it admits, PPIRP will commence. Pre-initiation phase will end, RP duties till that will end. If it is rejected, even then it will end. Now, what will, if it is rejected or not filed within the declaration time, he will get his fee from the corporate debtor. Otherwise, it will be given by the creditors, financial creditors. Now, how it, if my fee pertains to pre-initiation phase, just like in case we call as a before appointment of RP by the committee of creditors in CIRP, IRP fees is to be paid by the applicant. Similar way is in here also, RP fee will be paid by the applicant, that is MSME here. And if the PPI application is admitted, committee of creditors can ratify the fee before the initiation phase, and it can determine what fee will be payable during the pre-initiation phase. So what it is, PPIRP regulation specifically stating that I have taken initially for in this presentation, I have taken the important PPIRP regulations. And then we will go with the remaining also. Fee of the resolution professional. Who shall bear the fee of the resolution professional? If the corporate debtor fails to file an application or the application is rejected, the fee shall be borne by the corporate debtor, specifically written. What about the later on fee? If the PPIRP application is admitted, if PPIRP application is admitted, even then the management is with the corporate debtor. So RP is not in the duty of managing the corporate debtor as a going concern. It is not his duty. So what is it? Whatever be the amount the committee suggests is put in a separate bank, so that he can go ahead and meet his fee and expenses from that account only. That is what they are saying. Keep it separately in an account. Once PPI application is admitted, and this will be determined by the committee from time to time, whatever is the amount that is required to be paid as a fee and expenses to the RP. Now, application for initiation of CIRP will go in which manner? It will go electronically. If electronic provisions are not there, then it will go in the some drive form or pen drive form. Otherwise, it will be submitted electronically with a form fee 1 with a fee of ₹15,000. Now, if I go through this form 1, let's go through this form 1, because corporate debtor MSME is making application to NCLT. So, form of this application will be in the rules. All the forms are there in the regulation except this form when the application is made to the NCLT. How it is going to be made? Very small provisions are there, and we have discussed the same also. Filing of the application in form fee with a fee of ₹15,000, and then it is to be served. If simultaneously a copy of the application will be sent to the board by the registered post, speed post, or hand or electronic means, before filing it with the adjudicating authority, we know nowadays the application is first to be filed with the board also. And the rules are to be followed for the NCLT also. The corporate applicant shall inform if under the Companies Act any binding of petition begins against the corporate applicant, then it is to be informed to the adjudicating authority. Now, I look for this form 1. That is important for me because MSME will definitely be in touch with you to file this particular form. So we all know that this is going to be application, particulars of the corporate applicant and CD is there. Now, one question, if anybody asks from you, I don't have Udyam registration certificate. Is it mandatory to have Udyam registration certificate? For eligibility criteria of MSME, is it relevant? From where I will go and check it? I will go and check it in form 1, which is to be filed with the application to a dedicated authority, which specifically says in details of the corporate applicant that whether Udyam registration is there, give the certificate number as per the record there. And you have to attach the copy of the same. Or investment in plant and machinery or equipment and turnover. Otherwise, what is the criteria? Is investment in plant and machinery or and turnover also. So you give the details of that, which is calculated as per the notification. You have calculated it, give the detail of that and the proof that yes, your turnover and investment is like this and you are falling in the category of MSME. This is from where the justification is brought to. And that documentation should show yes, you are an MSME and you can go ahead and file this application. Then this part 2 will go for who is proposed to be the resolution professional, and specifically in this they will give the creditors who have approved the proposal and creditors who have appointed him. And when they are saying the creditors, they along with the creditors name, their debt and what is the percentage of their debt in total of the debts of the company. That will be given in the part 2 for justifying that resolution professional proposal is being approved by 10% and finally he is being appointed by the 66%. Then the financial debt and creditor details will be given, and when they will give the details, first of all they will give the details creditor wise and then they will give a detail about those who are not related parties. So form 1 is itself a speaking form which will tell us what is to be given in this form. So what data shall be with me? So I can take this data from form P2. The company has to prepare the data from form P2, as well as if any other record comes from the information utility or some other, it has to be given here. Then this will be given and an affidavit will be given that they are eligible and the RP has given its consent. It is being filed within the declaration date. And most important apart from this declaration is what are the annexures to be given. If they are talking about the financial debt, giving the details of the financial debt, then records of the details from the information utility or other documents have to be furnished. Underline this, if it is a case of operational debt, then in that case, they have to show that the operational debt. Someone is unmuted. Please mute yourself. I think Adarshji is unmuted. Adarshji, please mute yourself. Anshli, please ask him to be muted. So what was required in CIRP also, operational creditors tell you they need to serve a demand notice. The same has to be furnished by the corporate debtor also in case they have made a default in operational debt. Then they have to show that this is a service demand notice, 10 days notice has been given, record of information utility is available. That has to be furnished with form 1. Then approval of creditors in the first meeting and in the second meeting is to be given. Written consent in form P1 of the RP is to be given. Declaration of the majority of directors in form P6. Resolution, special resolution on member of partners which have approved this PPI RP applications. Then approval of creditors. See, creditor when has approved RP and when has approved application. Both the resolution will go there as set out in form P4. Here is the report of the IP which will be given in form P8. Declaration will be given in form P7. One more thing is to be done by the corporate debtor. If you underline this, just highlight, are you able to read this? Is this visible now? we know in all the CIRPs, there are the transactions which are known as by PUFP, preferential, undervalued, fraudulent, and trading transactions. This PPI-RP application is accompanied by a declaration from the corporate applicant itself that yes, these are the transactions which pertains to preferential or undervalued or fraudulent or insider trading transactions. If those are the fraudulent transactions, fraudulent trading transactions, they are to be reported by the corporate debtor itself. And then affidavit that it is eligible under section 29A, capital A, relevant books of accounts will be given. One more thing, they have to furnish audited financial statement. Audited financial statements of till what date? For how many periods? It is for the last 2 financial years and provisional financial statement made up to a date not earlier than 14 days from the date of the application. So that's why I said PPI-RP is not a one-day task. Whenever a MSME is planning for a PPI-RP phase, before giving the declaration, before convening the first meeting of the creditors, it shall be prepared with the documents. That these are the documents to be furnished, because this is a time-bound process. Just like in voluntary liquidation case, we are prepared with all the documents. Similar way, IP, if they come to for consultancy, we shall guide them that be prepared in the documents first, and then go with the process. A statement of affairs made not earlier than 14 days. And that they will give all whatever the assets, whatever the liabilities as are appropriate with estimated values. Another thing, what the corporate debtor itself is telling that these are the assets, these are our liabilities, and what is their values. Now, whether it can give on its own the values or it needs appointment of a registered valuer. Generally, they appoint the registered valuer for the process and find the estimated value. In case of any property on which the security is created or the claim has been raised or not, that name and address of the financial creditors and all other guarantors will be given. This is the most important thing. One more thing, being a corporate debtor, who is going to make an application on behalf of the corporate debtor? If it is a shareholder or a partner, then the CD has to give an extract of the constitutional documents like memorandum and article in case of a company, or shareholder agreement or LLP agreement, which is enabling a member or a partner to submit this application. If the application is made by an individual who is in charge of managing the operation like MD, CEO or CFO, having the supervision over the financial affairs, then he is authorized to do so. For that, they have to submit a relevant extract of the employment agreement, constitutional documents, or other resolutions which are being filed with the ROC. So that we are confirming that yes, the person who is writing his name as a deponent in the application, he is authorized to submit this application, because we know that whenever this application is filed, deponent signatures are there for the verifications and all the affidavits. Who is going to give this? This is a person who is authorized, and it will be confirmed by the constitutional documents. So I think the requirements of Form 1 is ready with us. If we are ready with the Form 1, then we can require it to start with the PPI. First, the documentary work is completed and then start with it so that it can be completed within time. As far as we are concerned, we shall complete it in time. Whatever the other hassles that is beyond our control, we cannot manage the same. Right, this was what the PPI-RP rules Form 1 was there. Now, when the information is relating to the books of accounts, this we have discussed, the audited financial statement of last 2 financial year. The regulation is saying provisional financial statement up to the date of declaration, but our Form 1 is requiring the financial statements up to within a gap of 14 days before the filing of the application. And then Form P5 is also submitted for the consent of the authorized representative to act as insolvency professional. What will be the order given by the adjudicating authority? In what time it shall give? Same, 14 days. Either admit the application. If admit, when it will admit, if it is complete, it will admit the application. Default is there, it is complete, all the documents are complete, PPI-RP commences. reject the application, but if the ground of rejection is application is not complete, so at least 7 days shall be given to rectify the same, and then consider the application. When I come to the post-initiation phase, my section 54D comes into. Now PPIRP commences. Within how many days it shall be completed? It shall be completed in 120 days from PPIRP commencement date. A shorter time period than the normal CIRP is there, and no extension is available here. This is how it is distinguished. 90 days are given to submit to the adjudicating authority resolution plan which is approved by the committee of creditors. If resolution plan is not submitted within these 90 days, if it is submitted, then 30 days are given to the adjudicating authority either to admit or reject the resolution plan. This is the one phase. Second phase is, which says how much important this 90 days is, that if no resolution plan is submitted on 91st day, it is the duty of the resolution professional to submit an application to adjudicating authority that terminate this PPIRP because no resolution plan has been approved in those 90 days. So that's why I say focus on what is the relevance. Here the relevance of time period is not. They are saying 90 days, approve it or terminate it. At least 30 days time period is with adjudicating authority, either to approve or reject the resolution plan. So this is there. What they are saying, that PPIRP to be completed within 120 days, and within a period of 90 days submit a approved resolution plan to the adjudicating authority. If not, then on 91st day, resolution professional shall file an application with adjudicating authority for termination of the PPIRP. Now, what is happening? You have given an application to initiate PPIRP. CD has given it in Form 1 electronically to the adjudicating authority. And before filing with the adjudicating authority, we have read in Form 1 also, we have to submit a proof that the same has been served to the board also. And then when adjudicating authority may reject, whenever rejection is there, grounds are always being mentioned, and it may admit it. If it admits, my pre-package insolvency commences. This is known as pre-package insolvency commencement date. Same three things will happen. First of all, RP will be appointed. So again, the RP's appointment for after the commencement will be by the only NCLT. Public announcement will be there and a moratorium will be declared. Three things will happen on this day. And these are the documents we have read from the Form 1 itself, that what are the documents to be attached with this application. Whenever PPIRP commences, within 2 days of commencement of PPIRP, corporate debtor has to submit a based resolution plan to the resolution professional. Though it has been submitted to the financial creditors committee, which took place at the second stage before PPIRP commences. But the same has to be given to the resolution professional within 2 days of the PPIRP commencement, because once PPIRP commences, the whatever be the communications between the CD and COC, it takes place through resolution professional. Once this, what else is required? Within 2 days, our resolution professional has to give public announcement in Form P9. And within 2 days, corporate debtor will give list of claims that was given in the committee of creditors in Form P10, as well as preliminary information memorandum. See here, it is the duty of the corporate debtor to give information about its creditor to the RP with the claims due with them, and a preliminary information memorandum. There is no such concept was there in CIRP. Now it is the duty of the corporate debtor to prepare a preliminary information memorandum, giving information about its financial position, giving information about its financial statements of accounts, giving information about its legal position, how much cases are going on. So that it is just like a prospectus. We can say that it is telling everything about it. So, And within 14 days, see this 14 days time period is from commencement date. So within 14 days of this PPIRP, resolution professional shall submit information memorandum to committee of creditors. Because only after this information memorandum is submitted, committee of creditors can evaluate the parameters on the basis of which it is going to consider resolution plan. One more thing is there. Earlier was the meeting being conducted by the corporate debtor. Now, within 7 days of PPIRP commencement, RP will constitute committee of creditors based on the information given in the list of claims, based on the documents submitted. And within 7 days of this constitution, first meeting of COC will be held. So my first meeting of COC is held in P plus 14 days. Is this clear that within P plus 14 days, this due will be constituted? Here it is relevant to see the format of public announcement. What it is asking. If I am going to give a public announcement, then what shall be in my hand or what the detail is required to be given in the public announcement. So I will go and check it from the regulations straightforward, which will help me in finding a difference in the public announcement in CIRP or the other processes and the public announcement in these cases. What is the difference between the PPIRP public announcement and CIRP public announcement? Sorry. Just coming to this is very relevant to note it down that what is our, and whenever we are being in practice, what I consider is instead of just listening for what we are telling, we should have a proof that from where we can extract this information. In the meantime, we can forget the information, but if we know the source, then we will not forget it. This is the public announcement format, if you go by it. Same that this has ordered it and this. Just go through it and tell me the difference between the CIRP public announcement and this PPIRP public announcement. These are 11 things you have to give it in public announcement. Can you point out the difference? If you remember in CIRP, creditors are required to submit their claim within 14 days of commencement date. They are being requested to submit their claim within 14 days of commencement date. But here what is being said, they are saying list of claims is made available from this date. There is no invitation to submit the claims. They already had a list. CD has already given a list of claims to the RP. So he is not asking the others to give the list of claims. He is not requesting in the public announcement that you submit your claim at this site or this site. No, it is straightforward saying if you want to go and check whether your claim is there or not, this is available from this date. List of claims are available from this particular date at the website of the company, at the website of the IBBI also. So this is what the difference between the this I just mentioned out in the public announcement when it is being made. They are not specifically being requested in the public announcement to give their name. And in the list of claims, we'll tell later on also, but just right now saying, and when this PPIRP commences, RP confirms the claims of the creditors from the list of claims, from the information utility records or any other record which is made available to him. And then he will send them email that this is your claim existing in our data. So individually, the creditors are being informed about their claims. This is my duty that I'm going to send it to the creditors. before this committee of creditors is constituted. Now, whenever this base resolution plan is given to the RP, RP will give this base resolution plan to the committee of creditors. Obviously, this is given in 2 days. So whenever the first meeting of COC be held, he will give the base resolution plan. Base resolution plan can be approved or it may be rejected. Or they may say, okay, invite the others. But when it is mandatory to make invitation to others to submit their resolution plan, when it is not approved by the COC, the plan which is being submitted by the promoters is not approved by the COC, or this base resolution plan impairs the claims of operational creditors. Then whenever the fresh resolution plan comes, they are competed with each other and then the base resolution plan, and the finally is approved by the 66% voting. We are going to go in much depth of it, but still now this is the overview of what will happen in the approval of resolution plan. So what will happen in the declaration of moratorium? Whenever a moratorium is declared, we know section 14 or subsection 1 comes into pick. That all the suits, all the no suit will be instituted. If anyone is going, it will not be further gone. Any order is given, it will not be executed. No surpassing proceedings are there, anything. Can you tell me whether section 14 subsection 2 will be applicable or not for the moratorium? Any idea? For the essential supply of goods and services, whether this will be applicable for the PPIRP or not?
No.
Any idea?
No.
It will not be applicable. Why will it not be applicable?
The
Just
corporate
a hint
debtor is on
needed.
board already.
Yes, the corporate debtor is already having the stake in it, so it will not be applicable. The essential supplies and goods will continue to be managed by the corporate debtor, so that is not required to be applicable at this stage. Then a public announcement is required to be made. Till when the order of moratorium be effective, it will be effective from till the time from the order of the commencement of PPIRP till the time PPIRP comes to an end. Means either the plan is PPIRP approved or rejected or terminated. So public announcement shall be in form P9. It will be sent to every creditor. It's not only in the website of the corporate debtor and the board. It will be sent to the information utilities. It will be sent to every creditor who is listed in form P2. So they are not saying public announcement to be in a newspaper. They are saying public announcement is sent to every creditor, to the information utilities and on the website of the CD and the board also. When we talk about the list of claims is given by the CD in form P10. Based on the records available, he will confirm the details. This is the duty of the RP. And now it is the duty of the RP to inform every creditor that this is your name confirmed and this is your amount confirmed, and if you have any rejection, please submit it with the supporting documents within 7 days. He may call for other evidence for substantiating the whole claim, and it is not that it is my whims and fancy, my choice, optional for me to consider the objection or not. If it is my duty to consider the objection, it means if I am rejecting it, I have to give a reason for the same. And if you are accepting it, modify the claims, update the list, and then submit it in the next meeting of the committee. Form P10 is available from the first COC meeting, in the meeting itself. That creditors, members, partners, directors, guarantors, whosoever wants, they can get it inspected. The same will be displayed on the website of the CD. Same will be there, filed with the board on electronic platform, and will be present at every meeting of the committee, along with the updation till that day. What are the duties of the PPIRP during PPIRP? Now, section 54F, 54B was saying what was the duty of the RP before PPIRP commence. Section 54F is saying what are the duties of RP after PPIRP commence. See, now till the time he is in a phase only just observing the management process, which is run by the CD itself, he shall conduct the PPIRP. It means he is going to conduct the meeting of committee of creditors. He is going to inform the creditors about their claims and all. So what is with respect to the claims? He will confirm the list of the claims, inform the creditors, and maintain an updated list. Simultaneously, though the CD is managed by the existing promoters, existing management, he is going to monitor the same. And if he observes that there is any breach of obligation by the board of directors or partners, he is going to inform the same. But this shall always be substantial. Meeting constituting the committee and convening, and then he has to attend all the meetings. On the basis of the preliminary information memorandum being prepared, he will prepare information memorandum. And simultaneously, if we come across any avoidance transaction, fraudulent or wrongful trading transactions, he has to file the application to NCLT, just like in case of CIRP also. Such as the duties as may be specified in the regulations. Simultaneously, he has the power to access all the books of accounts, reports, informations. You can have access to the electronic records of the corporate data from the information utility also, from the government authorities also. And apart from the committee meetings, whenever, if there are the meetings of the members, if there are the meetings of the board of directors, committee of directors or partners, he has a right to attend the same. Only then he will be able to observe how they are managing the CD at that time. If any other professional accountant, legal or required, he can appoint the same, but the thing is, he has to look into the regulation for the same. Simultaneously, he shall collect the information relating to the assets, finances, and operations to determine what is the financial positions, any avoidance proof for transactions existing, plus he shall get the information of the business, how the business was being run in 2 years prior to commencement date. What were the payments with the financial creditors and operational creditors in the previous 2 years? As on the initiation date, what was the assets and liabilities of the CD and other matters? And if the financial institutions and banks are there, which are maintaining the accounts of the CD. So whatever are the information relating to CD, they have to submit it to the RP as and when required. So we can always give a mail to the financial institutions or banks for any particular information required. Now, duty of the, it was in CIRP also that the personnel of the corporate data promoters or any person with whom the CD management is associated with the management of the corporate data, they shall extend all the assistance and cooperation of the RP. If we look for it, this is available in section 19. What our section 19 was saying? I think this is not, I just open it right. So whenever there is any reference of anything, just go through that reference itself. Like it is saying, see, section 19.1 is not required. Here they are saying section 19.2 is there. That any personnel of the CD promoter required to assist or cooperate, if they don't assist him, then resolution professional may make an application to adjudicating authority, and adjudicating authority will give this direction to the personnel or the employee that you cooperate with the RP for in collection of information and management. Okay. So this was my section 19.2.3 applicable, that he can always have an approach to the adjudicating authority if somebody is not cooperating. As regarding the fee of RP and expenses which are incurred in during the PPIRP, they will be determined by the committee of creditors and they will be put in a separate bank account. For the fee and expenses prior to the constitution of COC, that is prior to the PPIRP, prior to the constitution of COC, because COC is constituted within 7 days and then the meeting takes place in the 14 days. So whatever were the expenses till that date, if they are ratified by the COC, they will be part of PPIRP cost. This we have discussed the fee and professional expenses. Now, what are the claims and preliminary information memorandum? We know this information memorandum is to be submitted within 2 days. A list of claims will be submitted and that they will tell who are the creditors, what is their security interest guarantee, and a preliminary information memorandum. Now, if we say that preliminary information memorandum is just like a prospectus, if there is any omission of material information or there is any misleading information, then who is liable? If anyone on the faith of that particular misstatement which is there in the preliminary information memorandum or which is being excluded, not given, does something and incurs some loss, who is liable? Just like in case of the prospectus, it is a promoter or director of the CD, because preliminary information memorandum is prepared by the CD. So those who are the promoters, directors, or partners, or who has authorized the submission of the list of claims or preliminary information memorandum, they will be liable to pay compensation without prejudice to section 77 capital A. Means section 77 capital A is being introduced, and that is an additional penalty. Right? First cover this, then we will see what is the section 77 capital A. When can a person say that I am not liable for this loss? When he can prove that this list of claims or preliminary information memorandum was submitted by the CD without his knowledge or consent. So any person who has sustained the loss because of omission of material statement or information or inclusion of material information in list of claims or preliminary information memorandum. Now where they can go? They are not saying you can go to NCLT or NECLET. You can go to the adjudicating authority. No, they are saying you move to the court for compensation. This is what the difference is. Here they are not saying that anyone who is having loss because of misstatement in the preliminary information memorandum or list of claims, they have to approach the court and not to the adjudicating authority. Till this section 54G is talking about. Now, what is there in section 77 capital A? Let's see. What is the penalty they are giving? Section 77 capital A is saying that an application, corporate data provides an information in the application under section 54C, application to initiate PPIRP, or list of claims or preliminary information memorandum submitted to the resolution professional, and knows it to be false or omit any material fact. Such CD or person shall be liable with punishment of imprisonment up to 3 to 5 years or fine of 1 lakh to 1 crore or both. Any person who knowingly and willfully authorized publication of such furnishing such information will be liable for the same imprisonment and fine. If a director or partner of the corporate debtor deliberately contravenes the provisions of the entire chapter 30 anywhere, then section 77A is additional, saying imprisonment of up to 5 years can be given here, imprisonment up to 3 to 5 years, or fine up to 1 crore to 5 crore. 1 lakh to 1 crore, imprisonment up to 3 to 5 years. An application shall be deemed to be false in material particular case if the facts mentioned or omitted in the application, if true or not omitted, would have been sufficient to determine the existence of default. If they have taken those facts or out of the preliminary information memorandum, or they have put wrong information so that one ascertain that yes, MSME has committed a default. If anything is affecting the determination of existence of a default, then we say that it is punishable with respect to the list of claims of preliminary information memorandum of 54C, imprisonment 3 to 5, 1 lakh to 1 crore. Okay? This is what is in the hand of the adjudicating authority to be given. Now, how to manage the affairs of the CD? Who is going to manage it? Management of the affairs of the CD shall continue to vest in the board of directors or the partners, subject to the conditions that may be specified in the regulations. Now, what is the duty of the board of directors or partners? Their duty is to make every endeavor. What was the duty of IRP? To protect and preserve the value of the property of the CD. Same is the duty of the board of directors or partners. It was duty of the IRP to run it as a going concern. It is a duty of the RP to run it as a going concern and protect and preserve the value. Same is the duty of the board of directors or partners during the PPIRP. Endeavor to protect and preserve the value of the CD assets, manage its operation as a going concern. What is the duty of the promoter, members, personnel, and partners of the CD? See, here they are saying This is only of the board of directors and the partners of the CD, but now they are taking into account the promoters, members also, shareholders also, personal means officials of the CD and the partners, that they shall exercise and discharge their contractual or statutory rights and obligations. So whatever are the laws applicable for the CDs, who is going to comply with them? It is the duty of the promoters. If members or officials and the partners, they are going to comply. In the CIRP, it's the duty of the RP to comply with the laws relating like the filing with the ROC, filing with the GST, filing with the ITR return or anything. That was the duty of the RP. But now it is the duty of the promoter, members and partners and partners of the LLP. COC shall be constituted within 7 days of PPIRP. And what will be the base of constitution? What will be the list of claims being furnished by the CD? That will be the base for framing who will be the member of the committee of creditors. Composition of creditors may be altered later on if some updation comes from the creditor side, but it will not affect the validity of any past decision of the COC. First meeting shall be held within 7 days of the constitution. And they are saying provisions of section 21 except subsection 1 shall apply to the committee of creditors. So what are the provisions of section 1, subsection 1 here? If I look for section 21, they are saying because collection of claim is no longer responsibility of the IRP. So this is deleted. What they are saying, COC shall comprise of all the financial creditors of the CD, and those related or authorized representative which are related shall not have any right to of representation, participation or voting. And this provision shall not apply where the pursuant to the regulations, a financial regulator has converted its debt into the equity, and by virtue of that, it has become related party in the CD. If there is any consortium agreement between them, their voting share will, if there are 2 or more financial creditors who have jointly given a particular loan, then their voting rights will be proportionate to the loan being given by them. Same things which are applicable here will be applicable in the PPIRP also. One is a financial creditor as well as an operational creditor. Voting right will be proportionate to his financial debt. Any assignment, if any operational creditor has assigned or legally transferred the operational debt to a financial creditor, then the one who has taken such debt shall be treated as operational creditor to the extent of such assignment or legal transfer. The committee of, this is what one more thing here, the committee of creditors shall have a right to require the RP to furnish the financial information in relation to the CD, which shall be furnished by the RP within 7 days. Now, because the management is run by the CD, this is no longer the responsibility of resolution professional. Whatever be the information COC requires, it will directly require it from the CD, and CD will furnish it within 7 days. So they are saying here, later on they say, instead of this resolution professional word, substituted by the corporate. So now the duty to give the information to the committee of creditors is of the corporate debtor and not of the RP in this section 21. See, they are saying in the section subsection 9 and subsection 10, is for the purpose of resolution professional substituted by the corporate debtor or the RP. If there is any change in the committee required, can the composition be changed? Yes, it can be changed if any creditors give you a proof of claim that yes, my debt is like this, include my name or update my claim, and you are satisfied and you update the claim, then same composition will be changed, new member will be admitted, or if someone claim is not proved, he can be deleted. And such a change shall be intimated to all the members of the committee within 2 days of such change. So this is what my duty is. I will inform to all the members. I will put an email to all the members at the ID which is registered with the CD that this is the change now. This is these are the financial creditors. This is the amount of debt due to them. Who is going to convene the meeting of committee? It is RP who is going to convene the meeting. When he will convene, as and when he considers it necessary. When it is mandatory for RP to convene, is it mandatory? Yes, that is there in CIRP also. He shall convene the meeting if a request to that effect is made by the members of the committee representing 33% of the voting shares. Right? So if 33% of the members in value require the RP to convene the meeting, RP has to convene the meeting of the committee. Now, earlier when the corporate debtor was giving the notice, 5 days notice was required. Now, after PPIRP commences, RP is convening the committee meeting. How many days notice is required? At least 3 days notice in writing is required to be given to every participant at the address provided to the resolution professional by the creditor. Can a shorter notice be given? Yes. The committee may give a shorter notice. How much shorter notice? 24-hour shorter notice at least. But if there is an authorized representative, then at least 48 hours notice is required for the convening the meeting of committee of creditors. Now, what shall be the quorum? At least 33% of the voting shares shall be present. Now, what they are saying, they may be present in person. They may be present either by the in person or by video conferencing or other audio and visual means. Because we know that in notice it is always given that the members have an option to attend the meeting through video conferencing or audio visual means. Yes, quorum can be modified. 33% quorum is required to conduct the meeting. For the first meeting, this will remain 33%. Later on, if the committee requires, it can reduce it at a lesser level or more level. Where a meeting of the committee could not be held for want of quorum, then obviously it shall stand adjourned unless otherwise previously decided. So this is also in the hand of COC. What will happen if there is no quorum present? Then they say it will adjourn at the same time and place next day itself. And next day, whosoever is present shall co-rate the meeting. This is similar to just like in the companies that we talk about the members meeting or the directors meeting, if quorum is not there. So whosoever is present in the adjourned meeting, they will co-rate the meeting. What is going through video conferencing? The notice convening the meetings of the committee shall provide the participants an option to attend the meeting through video conferencing. So when as a RP, I am going to conduct any meeting of COC, I shall simultaneously go to make the arrangements, secured arrangements. That the meeting, if anybody wants, just like the link you are getting from the ICICI RP, the same is being sent to the members of the COC. That if you want to attend, this is a Zoom meeting through next link and through your mail ID, you can attend the same. Make the necessary arrangement to ensure uninterrupted and clear video or audio and visual connections. And he shall take all the due and reasonable care to safeguard the integrity of meeting. Integrity of meeting means no one who is not invited to attend the meeting is permitted to attend. Because this is a confidential meeting where the confidential things are being discussed, so they don't want any stranger to come and attend the meeting. And they have to ensure that the meeting is not interrupted by video conferencing or other audio visual means, so that the participants could not say that we are not being discussed with these things. He has to record the proceedings. All the proceedings will be recorded and the minutes will be prepared, and they will be safely kept also. Physical recording as well as the electronic recording will be kept safely. No person other than the intended participants attend or access. So just like we ask you to switch on your videos and all, similar way RP requires the members who are participating through video conferencing or other audio and visual means to attend the meeting while the camera is on, so that he can have a watch whether there is anyone else who is looking for who is there in the along with you or not. But with a differently able person, one person may be allowed to accompany. What shall be deemed to the place of the meeting? Meeting is convened through video conferencing. What shall be the place of the meeting? Whatever is given in the notice, and that shall be in India. It is not, you may attend it from anywhere, you may attend it from US, you may attend it anywhere. But there will be a place mentioned in the meeting, notice meeting, which will be India. Generally, the registered office of the CD is being mentioned here. And all the recordings of the proceedings at the meeting shall be deemed to be made at that place. Who is going to be the chairman? Resolution professional is going to be the chairman. And whenever, it's just like the CIRP, similar to CIRP, is going to conduct this meeting of committee, that whenever it starts, first of all, he has to determine whether the quorum is present or not. For this, he will call the name of every participant, whether he is present or not present, and he is present as a member, or he is representing any member, or he is an authorized representative, location from where he is participating, and then simultaneously ensuring that he has got the agenda and relevant material for the meeting. and no other one is attending him except no one else except him is attending from the location he is attending the meeting. Now participants, then thereafter a list will be prepared who are attending, and after roll call, and he will confirm that yes, these are the persons who are attending and the quorum is present or not. Meeting to be held in confidential environment from the commencement till the conclusion. So no one else other than the intended one is allowed to attend this meeting. There can be committee with creditors in a class which is conducted by the authorized representative. So whenever authorized representative wants to conduct a meeting of committee meeting of the class of the creditors, and then he will be given list of the persons who are belonging to this particular class 3 days of the commencement of the process. Within 3 days, whenever he requires, he will give a 3 days. These are the members of this class of creditors, and he will provide an updated list of the creditors. And it is not duty of the authorized representative that whose claims are being admitted, who is going to be the member. It is solely the duty of the RP to determine who are going to be the creditors in that class, and the same has to be furnished to the authorized representative. Even it is the resolution professional who will arrange the electronic means of communication between the authorized representative and the creditors also. And the voting share, just like this in the CIRP, it is same. It shall be in proportion to the financial debt, and this is only in the class creditors meeting. That whatever is that, they add 8% per annum to it from the date of default to determine what will be their voting share. And authorized representative will get fee for every meeting of the committee of class of the creditors. For every COC meeting, he is attending up to 10 to 100 in his class, 15,000, 101, 2,000, 20,000. If the member creditors in a class is more than 1,000, his fee will be 25,000. Before being the part of the committee of creditors, authorized representative has got the agenda as well as the notice. He shall circulate the agenda to the creditors and sort their preliminary view. Now, first of all, he will send a mail to all the class creditors along with the agenda to seek their preliminary views. And then he will open a window to submit their preliminary views, and this window will be open 24 hours after the mail being sent. And whenever this window opens, this window will remain open for 12 hours at least for submission of the preliminary views. And these preliminary views are not treated as an instructions for the voting purpose. One more thing is for the preferential and other transactions that is to be reported by the RP now after PPIRP commences. He shall form, similar to CIRP, first an opinion will be formed whether there is any such PUFE transactions in the organization or not. That the opinion has to be formed in 30 days. And finally, after forming the opinion, he has to determine, first is an opinion, then he has to go into depth, and from the documents he has to find out whether yes, these transactions are prevailing. Within 45th day, he will make a declaration. He shall make a determination, and then after making a determination, this time period is always calculated from the commencement date. He shall apply to the adjudicating authority for appropriate relief with respect to the PUFE transactions. Is there anything in the chat box you are asking? I think these are only the names that are being given here, right? Those who are attending. Fine. Approval of resolution plan. Before discussing the approval of resolution plan, can we have a break of 10 minutes? I think. Can we have a break of 10 or 15 minutes?
Hello.
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 Hello. Yes, yes.
Yes, ma'am, we can take a break.
Yes. Then please announce break of how much minutes you are announcing then?
Ma'am, 15 minutes.
15 minutes, fine. Absolutely
Okay.
fine. Within 15 minutes, we are going to reassemble and conclude the PPIR. We also with the case laws that have been there until this time in PPIR. Okay.
Fine, madam. Hello? Hello?
Shall we start the session?
Yes, madam.
Yeah. Okay. I hope everyone is back.
Yes, madam.
Starting your PPT preparation is excellent, madam. You are collating that code, regulation, rules, everything. It is, if it is possible, you please share in the chat box, madam.
I think everybody is back here. Let's start. I think the time is there. We shall start. First, sharing the screen. Screen visible to you?
Yes,
PPT
ma'am.
visible?
Yes, yes, madam.
Yeah. Okay. Now it comes approval of the resolution plan. How does it take place during PPIRP? First of all, we all know to begin with, this management is vested in the management is vested in the corporate debtor itself and not with the RP. But are there circumstances? Is there any checkout on the management? It's not that you have given a game in their hand and they can run it the way they want. No. There are some conditions for the management also to run the corporate debtor. And if they are violated, then the resolution professional will substitute them and management will be vested in the resolution professional. For what is required to be done? Obviously, the application will be made by the resolution professional to the adjudicating authority in Form P14. If COC at any time during PPIRP, with the vote of at least 66%, resolves to vest the management of the corporate debtor with the resolution professional. Once COC decides that the management shall be vested in the resolution professional, an application will go to the adjudicating authority. And what is required is, it's not only COC saying and adjudicating authority has to accept the same. No. It is saying it shall pass an order for vesting of the management with the RP only if it is of the opinion that during, it is not talking about before PPIRP management was run, however, no one is concerned. They are saying if during the PPIRP adjudicating authority is satisfied that the affairs of the CD has been conducted in a manner which is fraudulent, or there has been gross mismanagement of the affairs of the CD. So what is to be kept in mind is this fraudulent or gross mismanagement shall occur during PPIRP. Only then with the COC 66% approval, management will vest with the RP. And now, because the management is with the RP, at the time the fee was decided, it was also decided if the management vested with the RP, what will be the fee and the expenses to be incurred. And what they are saying, this is overriding everything. Now, which provisions will be applicable of CIRP? Until PPIRP comes, section 14.2 and 14.2A comes into pick. So what are relevant here is that they are saying section 14, 15J. Let me open that 14.2A. 14 to but earlier we were saying that the supply of essential goods or services, because they are being managed by the corporate debtor, so there was no need to interfere in it. Now supply of essential goods or services shall not be interrupted, and whichsoever goods or services are considered critical for essential for the running the corporate debtor as a going concern, they shall not be terminated, suspended or interrupted during the moratorium, except when the payment for such moratorium period is not being paid. So if RP wants to, for the purpose of running CD, essential goods or services, it can give an application to the adjudicating authority for that, and they will be continued provided the payment for that moratorium period will be made to them as and when it is due. So this is what is section 14.2 and 2A will be applicable. Then they say what it is saying. Our entire section 17 will be applicable. If I look for section 17, it is dealing with the management of the affairs of the CD. So all those, that was the duties of the IRP, when that he has to run it as a going concern, power of the board of directors shall be suspended and be exercised by the IRP, and officers have to report to the IRP. He shall execute in the name is now, whatsoever be the signing required anywhere. It's the RP who will do it. He will take all the actions. Authority to access the information utility records or books of accounts will be there. And one more thing is, earlier the requirement of complying with the law was with the management. But once the management is vested in the resolution professional, the requirement to comply with the laws applicable to the corporate debtor will be of has to be fulfilled by the resolution professional. Now, second thing, what they are saying our section 18, subsection E to G are applicable. Not entire section, it's section 18, subsection E to G. So what is there in subsection 18, E to G? Subsection 18 is the duties of RP, obviously collecting the A to F. If you will look for, they are collecting about the claims, and then the information collecting, taking over the assets, which that was a part of it. But now what they are saying, 18, from 18E, the role of the RP will start. That he has to file the information collected with the information utility, take the control and custody of the assets which are there, for which the ownership rights is vested in the corporate. That may include the assets may in the foreign country, maybe they are, though the assets may not be in the possession, but he has to take over the control, tangible, intangible, or the securities also. In that, again, the assets which are owned by a third party, but within the possession of the corporate debtor, they will not constitute the assets of the CD. If I look for the section 19, obviously now the officers of the CD have to cooperate with the resolution professional, and this section 19 and 20 are applicable in entirety, which are dealing, one section 19 is dealing with the IRP that they have to cooperate, and if they don't cooperate, he can always approach a dedicating authority for the assistance required. He has to run it. Again, what was the duty of the management? That endeavor to protect and preserve the value, run it as a going concern, appoint the legal accountants and professionals if necessary. He can go ahead with the same. For raising the interim finance, no security interest shall be created over a property which is already encumbered, without the prior consent of the creditor who is having that asset as a secured assets. But no prior consent is required if the value of the property is less than twice the amount of the debt. Is less than the amount equivalent to twice the amount of the debt. And instructions to be given can be complied with. Now, when I talk about the duties of RP here, section 25(1) is applicable. Section 25(1) is saying to preserve and protect the assets during the continued operations and including the continued business operations. Right? And then from 25(2), they are saying that 25(2) A to C. First, they are saying 25(2) A to C is applicable. So, taking the control over the assets, representing act on behalf of the corporate with third parties, or any right that may arise in the arbitration proceedings or by the order, he can exercise the same. And then he can raise the interim finance, but with the approval of the COC. A to C, and then it is saying K and G, section 28. and section 28 is applicable. So K and G of it is talking about, they are saying this. We know in section 28 mentions some of the actions which the corporate debtor cannot take place without the approval of the COC in a meeting of the committee of creditors. So the same is applicable here also. They are saying if any change in the management of the CD is to be made or transferring the right of financial debts under material to any other one, it has to be with the prior approval of the COC, otherwise it is not. Anything that is required to be changed, section 28 requires the prior approval. The same is applicable for the PPI RP also. Now, let's start with how this process goes on. PPI commences 2 days CD submit based resolution plan, which is given by the promoters or the CD that will be submitted by RP to COC. Now, COC may approve the based resolution plan if BRP based resolution plan does not impair any claims owed by the CD to the OCs. What is the meaning of impairment? Later on, when we will go in explanation, impairment means claims which are there in the list of the claims. They are admitted claims. And even if a single rupee is not paid, that means let's say it's a 40 lakh claim or 30 lakh claim, you are paying 29 lakh, 29 lakh 50,000, means even a single rupee haircut in any claim that is already admitted, then it is called an impaired plan. If base resolution plan is there and it is impairing the claims of the operational creditors, then in any case that will not be approved. Only it will be approved if it is providing for full payment to the operational creditors which is there in the list of claims. And if required, it may give an opportunity to revise it before such approval also. The word here is may. Even if base resolution plan is okay, it is not impairing the claims of anyone. Even then if COC, because we know the commercial wisdom of COC always prevails, it is not finding it fit and fine, it can reject it. It doesn't approve it. So within 21 days of commencement, within 14 days, first COC meeting will be held, all things will be provided. Then within 21 days, RP will invite. In this meeting, first meeting, they will decide whether to approve the base resolution plan or not. If COC does not approve base resolution plan or base resolution plan is impairing the operational creditors claims, in that case, RP will invite the resolution applicant. Then invitation to submit the resolution plan will be given in Form 11 to the competitive, to submit the competitive resolution plan. The resolution plan received. Now, COC will already develop the parameters on the basis of which the resolution plan submitted will be evaluated. So all the plans will be evaluated on the basis of those parameters, and the one which is getting the highest score will be the best alternate plan. There may be a situation that no one is getting the highest score, or even getting the highest score, COC is not finding it fit and fine. But the process goes that once this plan is not approved or it is impairing, then COC will keep it on hold, will all the other plans, will evaluate all those plans and find the best out of it according to the scores it has determined. And then what it will do, it will compare it with the base resolution plan. So first of all, the COC may consider the base resolution plan if no resolution plan is received. But if there is a best alternate plan, and that best alternate plan is significantly better than base resolution plan, then it may consider the best alternate plan. If no resolution plan received, it will consider then BRP again. If there is some plans received, it will evaluate them, and then whatever is the best, then it will consider the best alternate plan. And if best alternate plan is significantly better than base resolution plan, only then it will consider the best alternate plan. Now, after the comparison, significantly better, it does not approve a significantly better plan, then the process will terminate. It says, okay, we don't find it better. So it can close it. But sometimes what happens, best alternate plan is significantly better but not approved. Process terminates. Best alternate plan is not significantly better. Then starts Swiss challenge process. What is that Swiss challenge process? And that what they do, they disclose the parameters to the existing CD also and to the one who has submitted this best alternate plan. They will open the scores of theirs, both plan, and they will require them to improve their plan. If they improve their plan and then a best plan comes out, they may approve it, otherwise they will reject it. The one who is getting the highest score shall be considered for approval. If the highest score getting is approved, then that will be the final approved resolution plan. If not, then the PPIRP will terminate. Now that's why what they say is submission of the base resolution plan within 2 days of the PPIRP commencement date. COC may provide the opportunity to revise the base plan. It may require the existing CD that you revise whatever the proposal you are giving it, revise it. Or it may require that RP to invite the prospective resolution applicant whenever any base resolution plan or any other evaluated plan or best alternate plan is considered, they shall conform to the requirement of section 31 and 2 and 5